into the Shepherd's Rig wind farm, and we have hearing session 1 on policy today. So for the benefit of those who were not involved in the earlier session, my name is Rosie Leaven and I'm a reporter with the Scottish Government, and I've been appointed jointly with Miss Haywood to make recommendations to ministers on the wind farm proposals at Shepherd's Rig. And I hope that you can all hear and see me and that you can see Miss Haywood. Can you give me a thumbs up? Yep. Great, that's good. So I don't propose to repeat all the housekeeping matters, but if you are taking part, could you please keep your video on, but mute your microphone unless you're speaking. And to save time, we may just use thumbs up to indicate your agreement unless you've got specific concerns to raise. As usual, we'll be recording the session and the webcast recording will be publicly available to view on our webcasting site in due course. Again, for the benefit of those not involved in the earlier inquiry session, please could I ask everyone who's taking part today to introduce themselves, starting with the applicants team. Mr. Trinick.
Thank you, ma'am. Good morning, everybody. My name is Marcus Trinick, Queen's Counsel. I will not be leading in this session. The lead will be taken by David Bell, but I will be contributing at various points. Thank you.
Okay. Thank you. Mr. Bell. I can't hear you, but I can see you. Can we just check that your microphone's working, Mr. Bell?
Yeah. Sorry, I'm controlling the microphone. My fault.
Oh, okay. Oh.
Thank you. Good morning. Yeah, David Bell, planning consultant.
Okay. Okay, thank you. Thank you. And the council's team?
Good morning, Ma'am. My name is Douglas Armstrong. I'm Queen's Counsel, member of the Faculty of Advocates and Terra Firma Chambers, and I'm instructed by Laura Whitelaw of Dumfries and Galloway Council. And Chris McTeer, the Senior Planner at Dumfries and Galloway Council, will be the main participant in this session, but I won't be controlling his microphone, but I suspect I will be saying a few words during it.
Okay, thank you. Could we just make sure Mr. McTeer's microphone's working? Good morning.
Hi, good morning, ma'am.
Great, I can hear you fine.
Okay.
Yep, that's good. And Mr. Gordon?
Yes, I think I'm known to most parties already. I'm not sure if I control the microphone or it controls me. Can I just say, Mr. McTeer sounded, well, I could barely hear him. Sounded like he was in a diving bell or something. Okay. So I wonder if we could repeat the test with Mr.
Perhaps
McTeer's microphone.
Turn up your volume, Mr. McTeer, if that's possible.
Yes, I'll just have a
It is a little muffled, actually. Yeah. Maybe it's your microphone.
Maybe it's the microphone.
Yeah. Let's try that again.
Is that sounding the time?
It's still a bit muffled. I don't know if you can move it in a different position again. But if you turn up the volume and then we can try. Let's try one.
Yeah, volume should be up at maximum.
Yeah.
Now.
I mean, I can hear you. It's not perfect. So I wonder if you don't have access to another headset there, do you?
Yes, I think we can.
Well, that might be worth just trying once we get started. We can swap that in. But if you just go back
I can swap one out just now.
Yeah, well, do that if you could. Yeah, thank you.
Yeah.
Oh, that looks like a fancy set. Okay, do you want to try that again? Right, do you want to try that again, Mr. McTeer? I think you're on mute at the moment. Can't hear anything.
I think there's some teething difficulties with getting that system to work.
Okay, well, I will carry on with my sort of introductory remarks, but if you could maybe try and help Mr. McTeer. Yep.
Sorry, how this was my laptop was moving the software up.
I think that for me that's a little bit better. Mr. Gordon, do you think? Can you hear that okay?
No, I can't.
Sorry. I would say better, but not okay.
I'm having trouble hearing at all.
Okay.
We do have another headphone set which we can try. It may well be there's something up with the PC, but
Yeah. Okay. If you
Okay.
could try, continue to try fixing that during the course of my introduction, and then we'll take another mic check at the end of that. Okay. Thank you.
Okay.
So as discussed at the pre-examination meeting, the hearing sessions will take the form of a structured discussion, which I'm going to lead. There's no cross-examination of parties. You've also circulated hearing statements, and you will find them hopefully on your memory sticks. And we have considered all the evidence in your hearing statements for all 3 of the hearing sessions, so we don't propose to go through the statements themselves in detail. Instead, we've circulated agendas in advance with the areas that we would like to focus on, and I hope that you all have those in front of you. As we go through the agenda, you will obviously be given an opportunity to explain your position and elaborate on any areas of concern. And you may ask relevant questions informally through me. I will bring people in at the relevant time and indicate when we feel that we have sufficient information on the topic. As you'll be aware, the consultative draft of MPF4 was published yesterday, and although some of you may have spent your evenings reading it over dinner, we do all need time to consider it in detail. And so, as discussed yesterday, we will not be discussing the content of MPF4 today, but instead we will seek further written submissions on it after the close of proceedings this week. And thereafter, if we do feel that we need a further oral session on it, then we can take that forward. So is everybody comfortable with that? Thumbs up? Yep. Mr. Gordon, are you content, or are you about to press the unmute?
Well, it's just, does that mean we can't make any general reference to it at all?
I don't
spent
think we
yesterday
could.
evening changing my notes from what they had previously said to include
well,
some broad references to it.
Well, I think in fairness to all the parties, I don't think we should discuss the content of the policy today, no. And I know that is frustrating just in terms of the timing of its release, but we all need time to look at it and to be able to respond to the issues in it. So it will slightly change the discussion today, I know, but if we could just...
Sorry, ma'am, I was going to say that as I respond to your discussions, you may understand if I become a little even more inarticulate than usual as I try to work around my notes.
Okay, that's fine. Mr. Armstrong?
Ma'am, yes, I was just wondering, we haven't fixed a sort of timetable for responses in relation to MPF. Perhaps maybe that's something we could discuss at the end of this session.
Yeah, we will. Thank you. So we expect to keep to the original timetable now for the remainder of the week, which would see us finishing by tomorrow lunchtime, I think, but obviously we're keeping an eye on that as we go along. And I expect today's session to last until lunchtime, hopefully not too late of a lunchtime. And obviously there's a bit of flexibility around when we take lunch, and we will have a couple of short breaks during the morning as necessary. As it is the 11th of November, we'll also have a short pause at 11 AM to mark Armistice Day, and I'll ask you to mute your microphones at that point. So just to confirm, today we're starting now. We'll hopefully finish by lunchtime. Hearing session 2 will start at 2 PM, and that's on traffic and transport, and that involves a few different people. So we'll try and keep to that timescale, finishing later this afternoon. And then tomorrow's session on conditions will start at 9:30 and ending at lunchtime, hopefully. Are there any other questions before we start? Mr. Armstrong.
Ma'am, it's just one point which I don't think will affect today, but it was in relation to yesterday. You noticed that as far as the supplementary guidance is concerned, CD 506, that map 1 was missing from that. We're endeavouring to get a copy of map 1, but I think that should be available by tomorrow, and we'll lodge that as a document, or it might be as well just to have a sort of the whole document with that map in it.
Okay. That's very helpful, thank you. Okay, so we could just have another microphone check, please, with Mr. McTeer. Would you like to unmute and see if we can hear you?
Yep, no problem, ma'am. How's that sounding just now?
It's still not great, I have to say.
So okay, the microphone's up at maximum volume, so
Yeah, I wonder if you could maybe come out of the meeting and come back in again and see whether a fresh connection helps change the microphone. It may be, oh, yeah, it looks like he's maybe doing that. So if we could just pause while we try and get Mr. McTeer back in. Hi. Oh. Can you hear me, Mr. McTeer?
He can't hear you just now. I think.
Right. Could you advise him to maybe come out of the meeting and rejoin it and see if that helps?
I will.
We'll wait for that. Okay. Thanks.
Okay.
Purely for the purposes of checking my microphone speaking just now. Can everybody hear me clearly? Thank you.
I could hear somebody talking there, so
Hi.
I don't really
Hi,
know who it
sorry.
was.
Yeah, I can hear someone, but I can't work out who it is because I can't see the video.
Sorry,
Laura?
Mum. That was just Laura Whitelaw checking that her computer works. We may have to do if this doesn't work coming back in, then we may have to sort of try and get another computer.
Okay.
For Mr. McTeer to work from.
That's fine.
I
There's no
just
pressure.
said,
We're just.
I beg your pardon, ma'am, speaking over you again. I mean, Laura
okay.
came across quite clearly to me.
Okay, let's just wait and see if Mr. McTeer can get back in.
Okay, take two.
Hi, Mr.
or three.
McTeer.
How's that sounding now?
Still quite muffled.
Mum, I think it is an issue with the computer. So what we propose, if we could have 5 minutes, we will get another computer
Okay.
and try that. One that is definitely worked before. So if we could perhaps.
That's fine. That's absolutely fine. I think it's better to take the pause now and try and get that right so that we can all hear.
It will mean a bit of sort of shifting around because obviously Mr. McTeer's got all his documents on that, and so if we could have perhaps till 9:50, that should give us plenty of time to get everything in order and Mr. McTeer comfortable in his
Absolutely,
changed
no
position.
problem.
I'm obliged.
Okay, thank you. Hello. Welcome back. Any luck?
Mum, I think we have a solution in that we are getting another computer, but that needs to then go into the whole system here. And that is, I'm afraid, going to take about 10 minutes to
Okay.
get the other computer, get it set up, get Mr. McTeer's productions as well onto another document, onto another computer, and people are working on it, and I think it will take 10 minutes.
Okay.
Right.
Well, I think that is probably the best solution. So I'm sorry for the inconvenience for everybody, but I think we should reconvene at 10 o'clock so you can have your coffee break a little bit earlier this morning.
I'm obliged, and as I say, I'm sorry this has happened, but the speaker system seemed to be working okay earlier. But
Okay, no problem. So we'll reconvene at 10. Thank you.
just now.
N-
Start my video. Can you hear me just now?
Sorry, do you want to say a few bit more?
Testing. 1, 2, 3.
It's not as muffled, but can you put it a bit louder?
I can try. Yep. Just go into the settings.
Hello. Hi, Mr. McTeer. You're now called Laura.
Yeah.
But that's okay. Can you do a
I'm
little?
just adjusting the settings just now.
That's much better from my point of view. Could
that
others
okay?
confirm if they can hear? Okay, Mr. Trinick, can you hear Chris?
Good morning, Mr. Trinick.
Can you just try that once more? Sorry.
Good morning, Mr. Trinick.
That's perfect. Thank you very much.
Okay.
Great.
I
That
think
is
that's
good.
the solution now,
I'm-
Mel.
I just
That is
need
great.
to turn up the internal volume in these.
No, that's much better. Great. Okay, so do we have everybody back? I think we do. Great. So let's get started then if everybody's ready. Yep. So I've set out a number of questions. So we'll start with section 2 because we've already had our introduction. So we're starting with the energy policy, and obviously we have your evidence. So we've picked out a few areas just for further discussion. So the first question is about Schedule 9 of the Electricity Act, and obviously taking into account the decision of the Court of Session on the North Lowther case. I just wanted to get a view on the extent to which paragraph 3 of Schedule 9 will be met. Mr. Trinick?
Thank you, ma'am. Yes. For those not entirely familiar with it, we have 2 paragraphs of relevance in Schedule 9. Paragraph 3.1, which imposes a duty on people making applications under Section 36 if they hold an electricity generating or indeed supply license, or they have an exemption from the requirement to hold a license, to have regard to certain environmental matters. I can read them out if you want, but I don't think I need to. And a requirement to do what the applicant can do to reasonably do to mitigate the effects on the environment generally. That paragraph does not apply to the applicant in this case because it is not a license holder. There's no current requirement to hold a license, and therefore there's no current requirement to attain an exemption from the need to hold a license. It doesn't apply. That issue was specifically considered in the judgment of the court in the petition of the North Lowther Energy Initiative, CD 950. And in paragraph 17 and 18, the judge, Lord Eric, confirmed what I've just said about that paragraph. I need to rehearse it in more detail. Paragraph 3.2 applies to the Scottish ministers, and it requires them, when considering relevant proposals, and this is one of them, to have regard to the desirability of the matters referred to in 3.1, that is, desirability of preserving natural beauty, etc., and to have regard to the extent to which an applicant, any applicant actually, has complied with his duty. Now, obviously, there's no duty, but it's certainly, I accept that the Scottish ministers will have regard to the extent to which any applicant has done what it reasonably can to mitigate the effect of its proposals. The duty is to have regard to. It doesn't impose a substantive development control test. So provided that you provide sufficient information to the Scottish ministers in your report to enable the ministers to have regard, then the requirements of paragraph 3 of Schedule 1.3 of Schedule 9, sorry, paragraph 3 of Schedule 9 are met. And I note that the position I've just articulated in terms of there being no substantive development control test was also taken by the ministers in the Falago Rig 2 decision, electronic page 8 of 29, CD 915. I don't think I need to say more, ma'am, unless I can help you.
No, that's fine. Mr. Armstrong?
Ma'am, as far as the summary of the law is set out in the North Lowther decision in CD 950, I concur with Mr. Trinick's summary of what's set out in the case. It's obviously up to the Scottish ministers at the end of the day whether they have enough information to properly have regard to the duties upon them.
Okay, thank you. Mr. Gordon, did you want to add anything? No. Okay, thank you. So question 2B was around the new legally binding targets, and I just wanted you to clarify your understanding of what the targets are and what weight ministers should give to such targets in the face of energy and planning policy more generally. Mr. Trinick?
Over to Mr. Bell.
Okay.
Thank you. In terms of answering this, I thought it easier just to go through a few points. Firstly, with reference to my hearing statement, in that on page 44, I set out a table which sets out the legally binding targets that are derived from the Climate Change Emissions Reduction Targets Scotland Act 2019. So that's table on page 44 sets out the targets for each year. So the government set a specific target for each year running right up to 2045. And we've got information so far on 2 years, 2018 and 2019. And you can see in the table I've put in what the actual figures were. So we're way behind at the moment in terms of those targets. We're still awaiting last year's data against the 56% reduction. So the annual report on emissions, we've got the June 2021 report, which is CD 7.45, which contains that information on the last year for data that's available. I think there's two key observations I would make. One is that the government specifically raised the target for 2030 to 75%, which goes beyond the Committee on Climate Change advice for Scotland. And it was evident that the Scottish Government wanted a very ambitious target. And I think for those people that have been following the COP26 events, that was discussed at some length. And the government made it clear that it was an ambitious target that they wanted for 2030. And indeed that year, see it in the COP26 statement that will come out later this week, 2030 is a critical milestone date in getting to net zero. The other observation I would make is that in terms of the percentage increases, it starts off quite gentle, 54 to 55 to 56%. At the end, but then from next year, the pace increases and the amount of emissions reduction increases. And you see that through the percentages running up to 2030. So the level of change that's required to achieve the 2030 target is like a doubling of the response compared to the early years when the Act kicks in. And that means that the trajectory of emissions reduction is steeper, and the 2020s is the critical decade. So that's the information I put forward on the targets. The position is, in summary, that we are way behind in terms of the targets. They are legally binding, and in terms of the point about the weight, I would say a substantial weight should be afforded to the benefits of the development insofar as it can assist in attaining the net zero position.
Okay, thank you. Mr. Armstrong?
Mr. McTeer will address this point, and I suppose he's really dealing with bullet points 2 and 3. I think it would be helpful if we had to hand CD 930 and CD 927. That's the Galty Clay report and the Crystal Rig decision letter, because I think it's Mr. McTeer's intention to refer to both these documents. That's CD 930, the Galty Clay report, and the Crystal Rig decision, which is CD 927. And on that, I'll hand over to Mr. McTeer.
Okay, just hold a second till we get those documents up. Thank you. Okay, thank you.
Thank you. I'm not going to add very much to Mr. Bell's narrative on the targets. They are
Okay.
very ambitious, particularly the 75% reduction by 2030. But in terms of the weight given to the targets, I wanted to go to document CD 927 first, which I think is a case that you'll be familiar with. And we're looking at some of the most recent decisions that have come from the Scottish ministers. In this case, it was March 2021 for Crystal Rig 4, page 15 of CD 927, so discussing the application of weight to this. And you need to apologise. I did have everything set up on two screens, but now I'm having to refer to things on a separate laptop. So just have to bear with me a second. But the very first paragraph, when we're sort of looking at renewable energy technology, the last sentence there says, in Scotland there's been a significant progress towards low carbon objectives whilst continuing to protect our special places from significant adverse impacts. And following on from that, onto the third paragraph, second sentence in, where it says the aim is to achieve the correct development in the right place. It is not to allow development at any cost. Turning to the other decision, the one for Galty Clay, this is the reporter's report again from March of this year, onto to page 33 of CD 930 and paragraph 2.73.
Just a second. Can you slow down a second just till I get to that paragraph?
Okay, no problem.
Page 33, did you say?
Yes, ma'am.
Okay, thank you.
So we can see in his report, or in the reporter's report, for the following reasons, I'm not persuaded that the Scottish Government did intend any diminution in the protection of the environment or its importance in the balance, even upon the introduction of the new targets. The next paragraph goes on to say that I've not found anything express in the Scottish energy strategy or the onshore wind policy statement that suggests that the considerations of environmental protection at any particular site are altered such that environmental protection is intended to be reduced to allow development where it would previously have been unacceptable. And there is an emphasis in both documents on continuity of protection, including the protection of landscape, and on development being in the right place. If a change had been intended in the degree of environmental protection to be applied in respect of onshore wind development, I consider the two documents would have said so expressly. Going on to paragraph 2.77, where the reporter goes on to say that onshore wind is not the sole renewable energy source considered by the Scottish energy strategy. Onshore wind's role in achieving the targets is recognised as vital, but the strategy also takes account of the contribution that can be made by a number of different renewables technologies, including offshore wind, island wind, wave and tidal power, solar power, hydropower and bioenergy. The Scottish energy strategy refers to the potential of these sources, and they are capable of making an increasing relative contribution to meeting the renewable energy targets. While the strategy recognises advantages onshore wind has relative to other forms of renewable energy generation, particularly its currently relatively low cost, the strategy also refers to constraints such as the effect on Scotland's landscapes. And I do not consider the evidence before me as such as to cause me to conclude that in practice only onshore wind can make a substantive contribution to meeting the energy targets. Paragraph 2.85 on page 35 says the Minister's decision on the proposed development must be taken with the increased emissions reductions targets in mind. However, I still do not find there to be a necessary implication that an effect on the environment that was unacceptable before either the enactment of the 2019 Act or the recognition of the global climate emergency has become acceptable as a consequence of those events. Now, we feel that these clearly sum up the Scottish Minister's position, even with the introduction of the increased targets and the climate emergency. So that ties in with the Council's position on these matters, that inevitably, if you give more weight to targets, you inevitably give less weight to the environment.
Ma'am, I think just for completeness, in the Galty Clay case, the report was dated 20th February 2020, but the actual decision letter of the Scottish Ministers, which adopted the reporter's conclusions, which is document CD 929, is the 24th of March of this year.
Okay. Thank you. Mr. Gordon, did you have anything to add on question 2B?
Yes, please, ma'am. As far as Mountaineering Scotland's concerned, it's not the legally binding target that is key, but the policy target to increase onshore wind capacity by 8 to 12 gigawatts by 2030. We presume that has been worked out to support the 75% reductions in emission by 2030. And clearly,
I would like, could I just say, I would like to have a specific question on that issue at the end of section 2 here, just about the 8 to 12 gigawatts. So we will come back to that. Okay. Carry on.
Clearly and rightly, that onshore wind capacity target has considerable weight. But in our view, that weight is not new. There's been consistent, strong policy support for onshore wind for many years. The question whether the weight has now become so significant that it trumps all other considerations in individual planning applications. We think that's not the case, and we certainly hope it's not the case.
Okay.
Thank you, ma'am.
Okay. So the third bullet point under 2 does. Oh, sorry. Yeah. Just to check if Mr. Bell had anything else to add.
Yeah, yes, thank you, Mel. Just to come back on a few points, I think the view in my hearing statement is very much that there's a move to going beyond what might be termed a business as usual situation with SPP and NPFT. We'll come on to that. And what we are not saying is that significantly less weight has to be given to environmental considerations, but it has to be recognised, I would say, that in classic planning judgment, it is open to decision makers to place more weight on the benefits of a development if policy is going in that direction, and that I would say is the case here. Also, we'll come on to the role of onshore wind that Mr. McTeer has referred to. And whilst the 2017 energy strategy is relevant, matters have moved on with the onshore wind policy statement, and we'll come on to that on the agenda. Mr. Gordon was saying, does that trump everything? No, it doesn't. It doesn't give carte blanche for every scheme, but it does mean that the matter of weight is very important in the judgment. That is what we are exploring.
Could I just add, ma'am, to that if you view the planning balance as a sliding scale, somewhere along that scale is a tip point where you either decide to refuse or to grant permission. What I'll be saying in closing submissions, what we're saying now, is that tilt point, we say, has shifted along the scale in favour of granting more permissions. And insofar as any reporter says otherwise, I'll say bluntly, that reporter would be wrong and would have made a mistake in terms of interpreting properly what has happened as a result of the climate emergency, net zero, and the legally binding targets. That sounds a strong statement. I make no apology, it is. And I think that decision makers need to listen to that message, if I'm right, of course. Thank you.
Okay, thank you.
Ma'am, if I could just come back on that last point, I submit that as Mr. Bell accepted, Mr. Trinick seemed to be at odds with what Mr. Bell was saying there. It is ultimately for the decision maker to decide what weight should be attached to each relevant material consideration. And that's very much up to the decision maker, unless there is a statutory framework which directs that specific weight should be given to a particular material consideration. And in this case, there's no suggestion that that is the case. So Mr. Bell on this occasion is correct. And with respect to Mr. Trinick, he is wrong, unless he's suggesting that if a reporter attach more weight to environmental issues than energy policy and target issues, then that reporter is acting unreasonably and in a way that no reporter would so act, which is a very high test. And I'd submit that the courts would reject the type of submission that Mr. Trinick is making out of hand.
May I just come back on that, ma'am?
Yep.
I don't think Mr. Bell and I are apart at all. He's just more polite than I am. So far as yes, of course, the trite phrase "weight is a matter of the decision maker." Well, of course it is, but it's not simply at large. You can decide to attribute whatever weight you want to any particular issue. It's in the context of the documents which we put forward in relation to the need case, incorporating climate emergency, net zero, etc., and the legally binding targets. Let's not forget that phrase, legally binding targets. So it's not a judgment at large, it's a judgment which is constrained by the factors to which Mr. Bell has drawn attention in his evidence and to which I have just drawn attention. So no, I'm afraid I disagree with Mr. Armstrong.
Okay, thank you. I'm conscious that the third bullet under number 2 is straying into similar ground. Is there anything else that parties would like to say about the need case in the face of such targets?
Yes, sorry, ma'am, is that the question about Mr. Gordon's paragraph 4?
No, the one previous, the third bullet. It's really actually part of the same question.
Until we get later into some other matters on the agenda.
Okay. Mr. Armstrong, are you happy we go on to the next
I
bullet?
think Mr. McTeer really addressed both these bullet points, I think, in his response.
Yeah. Great. Okay, so the fourth bullet point is taking us to Mr. Gordon's hearing statement, where he states that the policy or position statements published neither diminish support for onshore wind nor explicitly increase support. So to what extent does the applicant agree that there's no additional policy support for onshore wind now than there was prior to spring 2019? Mr. Trinick.
I go first on that. I think fundamentally we don't agree with that proposition for the following reasons. Prior to spring 2019, the importance and role of onshore wind was set out in the energy strategy and the onshore wind policy statement. But what we've had is the 6th carbon budget since the 2019 date. That's CD 7.26, and just taking it short on that document, all the scenarios for the future see onshore wind generation being deployed by 2050, and the capacity is generally 20 to 30 gigawatts of onshore wind in all the scenarios in the 6th carbon budget, which is now in law. The 6th carbon budget has been put in law by the UK government. Secondly, the Energy White Paper, which is CD 7.28. I refer to this at page 39 of my hearing statement, but the White Paper of December 2020 states that onshore wind will be a key building block of the future generation mix. Not simply that it has a role, but it is to be a key building block. Now, we've also got the onshore wind policy statement refresh from October 2021, very recent, CD 7.53. Now, I fully acknowledge it is a draft, it's for consultation, but the Scottish Government in that document sets out its current position. There are various statements such as "we believe," "it is our view," and so on. So in terms of the matter of weight to go to this document, we will make position on that some weight should be attributed to it. Now, to give just three example of four references, paragraph 1.1 states that meeting the commitments of the 2019 Act that we just talked about earlier will, quote, require decisive and meaningful action over the next 12 months. Now, actually, I have to say, I don't know why it's just 12 months. I think that's perhaps an error, because it's going to be more than 12 months requiring decisive action. But the other important reference is at paragraph 1.2.2, where it says, with regard to onshore wind, we must now go further and faster than before. We expect the next decade to see a substantial increase in demand for electricity to support net zero across all sectors. Goes on to say, some estimates from the Committee on Climate Change suggest we could expect a doubling in electricity demand. This will undoubtedly require a substantial increase in installed capacity across all renewable technologies. Then at 2.1.1 of that document, in terms of future position in net zero, it sets out that the transition to net zero means that our demand for green electricity will increase substantially over the course of the next decade. This means that a consistently higher rate of onshore wind and other renewables capacity will be required year on year. So this goes to the point that we just discussed earlier, I think, about where that tipping point is for decision makers. Decision makers will need to act upon this, now accepting that this is a draft and will come forward in its final form in due course. Now, I think the last point I would make about the proposition that Mr. Gordon's put forward, that there's nothing before us that tells us that we should be giving any more support to onshore wind for 2019. And why I would say, with respect to Mr. Gordon, he's not correct on this, is that the Butte Agreement, which is the agreement that cements the confidence and supply arrangement between the SNP and the Green Party, that's now been reflected in the programme for government. That's CD 7.51. This electronic page 17 sets out that all renewable energy projects over 50 megawatts will be designated as national development. So that is the intention in the policy. And for the statutory NPF4. Now, I don't want to stray into that territory too much, but we do get that matter foreshadowed in the Butte Agreement. So this development, subject to this application, will be, should that legislation go through, national development in terms of the benefits and the need case. We see that in the Butte Agreement. So to say that there's nothing that shows that there's any additional policy support for onshore wind, I would say that is not correct.
Okay, thank you. Mr. Armstrong?
If Mr. McTeer could just come back on some of the policy points that Mr. Bell has raised just now.
Yes, thank you. Can you hear me okay? Sorry, you just vanished for a second there. Yeah, just a couple of points, if I may, ma'am, on the onshore wind policy refresh, CD 7.53. I do note and agree with Mr. Bell. It is a draft at present, but and without straying too far towards NPF4, it does give the direction of travel, or certainly direction of policy travel, kind of going forward with that. But the ministerial forward on page 2 of the policy refresh document does say, however, we are determined to ensure that any capacity is developed in a way which is fully aligned with and continues to protect our natural heritage and native flora and fauna. Obviously, looking at onshore wind, it doesn't include everything in the sort of the policy refresh. It does highlight repowering in section 2.2 as playing an important role in providing additional deployment. But it does say that it's not the case that all developments will be considered appropriate for repowering, and that all the relevant consent and planning permissions will still need to be in place. Section 4.2 of the policy refresh on land use strategy does include references to the right development in the right place. And yeah, again, back to paragraph 4.4.2 about deploying significant onshore wind over the next decade, which is a point that Mr. Bell did highlight. But the following paragraph does say that developers are encouraged to discuss with the planning authorities appropriate sites for wind turbines at an early stage with reference to the adopted local plan or local development plan, if you will. So yes, that's really all I wanted to say on the subject of that. But yes, it certainly does give the direction of policy travel, but noting that it is just a consultative draft at present.
Okay, thank you. Mr. Gordon, would you like to add anything? I don't see you. Have we lost Mr. Gordon? Doesn't seem to be there. Let's just pause for a minute, see if we can get Mr. Gordon back. Callum, I don't know if you're hearing me, Callum. Is Mr. Gordon in the lobby? Apologies for the delay. I think Miss Haywood is just going to go and see if Callum can find Mr. Gordon. Given that it's his points that we're discussing, I think we definitely need to wait for him. Hi. Can you hear us, Mr. Gordon?
Yeah, my apologies, ma'am. I didn't touch anything.
Oh, that's okay.
I simply suddenly disconnected.
Right. Could you let us know at what point you disconnected? Was it when Mr. McTeer was talking?
It was while Mr. McTeer was speaking, yes.
Right. Okay. So do you want him to recap or recap anything that he was saying before you are now getting a chance to respond?
No, I'll just happy to press on, ma'am.
Right. Okay. So it's your opportunity to respond to that question about paragraph 4 of your statement.
Right. Yeah. I mean, I would start by saying that statement was written in early July 2021. Things have moved on, and we'd undoubtedly now make a more qualified statement. Current policy, and this is the point, not draft, but policy contains the 8 to 12 gigawatt target. We would argue that that's achievable without sacrificing good quality landscapes. And while little weight attaches to consultative documents, there does seem to be a drift away from the existing policy balance between landscape protection and energy generation that we think has actually worked well for the last decade. And I take issue with Mr. Bell. It may not quite be business as usual for the coming decade. But I think all we need to do is pedal a little faster, not sort of stick an engine on the bike and convert it into a motorbike that can accelerate off into the distance. That's a terrible analogy. And I just make the point that in the past decade, something like 10 gigawatts was actually consented. Consenting similar in this decade would get close to achieving the target. So we need, I can see Mr. Bell shaking his head, but you know, my view is I would concur with Mr. Bell to some degree. We need to step up the pace. but I don't think we need to step up the pace to the extent that he suggests. And certainly not at the expense of good quality landscapes.
Okay, thank you. Mr. Bell, would you like to come back on that?
Yes, thank you. I think firstly I would agree with Mr. Gordon about best quality landscapes, and I think we know from the position statement that the government's made it clear that in terms of national parks and NSAs, they will be prime top tier, if you like, designations for protection. But in terms of, this has been practiced for many years, in the spatial framework approach, local designations such as an RSA or a special landscape area do not feature in the spatial framework. They are group 3. So the government's made it clear that these areas are within the areas in which wind farms are likely to be acceptable under the current spatial framework. Of course, there are considerations, but that is where they sit, if you like, in that hierarchy. And that will be further explored in the NPF4 representations to come. But I thought it might be helpful just on the target. In fact, it's not, it's referred to as an ambition in the onshore wind policy statement. But in terms of the numbers, I thought it might be helpful just to explore that just for a moment relative to what Mr. Gordon's saying about the consented capacity, because that is a frequent question that arises.
Yeah, well, actually, I was going to ask that myself. So I wonder if I could just ask if you've finished off what you'd like to say about Mr. Gordon's statement.
Yep.
Then I just wanted to, I think this is a good point just to ask a little bit more about the figures in the, I presume we're talking about the same thing, the figures in the onshore wind policy statement refresh. Yes. So obviously that's the consultative draft. This is a new question that's not on the sheet, but it follows on anyway. The consultative draft CD 753. So it suggested an additional 8 to 12 gigawatts installed onshore wind by 2030. And it also suggests 8.4 gigawatts already installed, 9.7 gigawatts are in the pipeline. So I wanted to get a feel for your understanding of whether that 8 to 12 gigawatts was additional to the 9.7, or is it part of that? So if Mr. Bell could maybe start with your views on that.
I've got my own draft table in front of me, so I will do my best to explain a table without it being shown, if you like. But
okay.
Just for my own analysis of this, I think the starting point would be that in the onshore wind policy statement, paragraph 2.1.4, the Scottish Government places some reliance on what's called the onshore wind prospectus, which has been put forward by industry to say that there's a need for Scotland to develop an additional 12 gigawatts, which would mean a total of 20.4 gigawatts for Scotland by 2030. So at the moment, there's 8.4 gigawatts of capacity that's running in Scotland. And in terms of what's in the planning system at the moment, the paper refers to 4.69. Now, I've just taken, for the sake of this illustration, a figure of 4.8 in planning, which I've taken from government website data. So if you assume that there's, say, 4.8 in the planning system at the moment, I think a reasonable assumption would be to say that, well, you could potentially get 2.5 gigawatts coming out as consented developments, about half, just under half. That seems to be the statistic held up by the statistics through appeals, inquiries, and local authority consent. The next category was the consented capacity, and that's in the table at 4.6 gigawatts. And I think there's a real difficulty with a lot of the consented capacity, and the Scottish Government's always maintained the view that that cannot be relied on for a number of reasons. One of them is that a lot of the consented developments are low tip heights, and when the subsidies fell away, a lot of these projects simply became unviable. That's why we're seeing a lot of tip height increases coming forward. And a lot of my practice is dealing with that type of application. And for example, in Dumfries and Galloway, there's one, Mr. McTeer will know, Morecambe Fell. It's a consented scheme, but it's consented, I think, at 125. It's coming in, Chris, I think it's 149. I forget the exact height, but it's, you know, that's one example of one of the schemes in that basket that doesn't work at its consented level. I think a lot of consents will lapse as well in terms of their dates for implementation, and others are affected by aviation constraints and so on. So I've assumed out of the 4.6, it might only be about 1.5 that comes forward. And I think the industry bodies will be giving evidence on that in due course as part of the OWPS response. Then the other category is await under construction, which is about 0.5, which I think is fair to say that that would continue to construction completion. The other figure is repowering, and my experience is actually rather than repowering of developments, it's probably going to be more life extensions that are coming forward, and that's what we're seeing. I think there'll be a few repowering projects like Hagshaw Hill that's consented, but I think investors and owners will probably find that the life extension over the next decade is the better approach. But I've assumed, say, 1.5 gigawatts could come from, say, repowering. So if you add up those figures, the in-planning contribution would be 2.5, consented 1.5, under construction 0.5, repowering 1.5. That's 6 gigawatts. So if you add the 6 to the 8.4 we've already got, that takes you to 14.4. So you need another 6 gigawatts of new capacity to get to that 20.4. So put another way, 6 gigawatts of additional development is the equivalent of 60, 100 megawatt wind farms. So that's just to visualize what does that mean in terms of additional capacity. But of course, there's also the 2.5 to come through the in-planning, which is overall 8.5 gigawatts of capacity yet to be consented. And of course, this scheme would fall within that basket of the in-planning as part of that 2.5. So that is one way of looking at the target, if you like. It's maybe not exactly correct, but I think the broad structure of the figures is probably about right. But of course, that will come through evidence to go to the government over the next period during their request for that under the OWPS consultation.
Yep. Okay, but that's helpful to get your views. The council?
I think Mr. McTeer's going to come back on this one.
Okay.
Yeah, just I'm not going to make any great calculations for that, but other than to draw your attention back to the document at chapters 2.1.3 and 2.1.4 with the figures that are sitting in there.
Okay. That's fine. Mr. Gordon, would you like to add?
Yes, ma'am. Apologies. I seem to have left my microphone on throughout.
Okay.
I mean, the figures Mr. Bell has been giving vary very slightly, but they're essentially the same as I submitted in my CD 7.52. What he does with them is not very different from what I've done in my own calculations. I'm slightly less pessimistic than he is about how much that's currently in planning will become consented. I've got 3 gigawatts, he's got 2.5. I think that's neither here nor there. I think the big difference between us is how much of consented capacity will actually, in due course, become operational capacity. Now, I only look at ones that affect mountaineering interests. Of those, I'm only aware of 2 previous consents, one of which I mentioned, I think, yesterday at the Tors wind farm, which effectively haven't materialised as turbines on the ground. I bow to Mr. Bell's much greater inside knowledge of how things are going than I have. But I am surprised that he thinks such a small amount of the consented development will actually materialise. I think I'll just leave it at that, ma'am.
Okay. Mr. Bell, is there anything else?
Sorry, may I just, apologies, may I just add one other point? Mr. Bell started off by referring to, wanting to protect good quality landscapes and mention national parks and national scenic areas. I think the thing is, we almost need a national debate on what actually constitutes good quality landscapes, because we don't think they're just restricted to national parks and national scenic areas. And interestingly, in a document recently, sorry, bear with me, I tried to find the reference. Yeah, CD 753, which is the draft onshore wind refresh, refers to, I can't remember the exact context, but refers to cherished landscapes as something that they want to protect. And I simply noted yesterday, as we went past document CD 518, the Dumfries and Galloway Regional Scenic Areas technical paper, that they refer to RSAs as part of, quote, our most cherished landscapes, unquote, on page 2. Now, I accept that's not national policy, but I think we run into trouble when we get undefined terms like cherished landscapes. And clearly, my definition of cherished landscapes is not quite as narrow as Mr. Bell's. Thank you, ma'am. That's me.
Okay. Thank you. Mr. Bell?
I think the figures are actually quite illustrative. The actual under construction is low. It's 0.5 gigawatts when you look at that against the consented capacity. And just to give some examples, Limekiln wind farm originally consented, but is under an application for a tip height increase. Strathy, big development, taking up a big chunk of capacity, subject to a tip height increase application. Kieran Sector 36M, subject at the moment to a tip height increase application. Morecambe Fell, Dumfries and Galloway, just mentioned. Millennium South, unimplemented. That's just a few that I'm involved in. There are others. So that together is probably over 200 megawatts that is currently being reworked.
Just to help Mr. Gordon there, the paragraph within the draft OWPS refresh document, which you referred as 442, that's where it says most cherished landscapes, just to give a reference for that.
442. Okay, thank you. Okay, I think that covers that bullet point. So the 1, 2, 3, 4, 5th bullet point takes us to paragraph 7 of Mr. Gordon's hearing statement, and that is about the greenhouse gas emissions figures 2019, and they indicate that emissions reductions have stalled for the last 3 years despite increases in renewable energy generation. So I'm interested to find out what proportion of the solution you think to reducing emissions is renewable energy expected to make. Mr. Bell?
Yes, I think it's a fundamental contribution to the solution of reducing emissions. Clean energy is the shift we are all embarking on, and I think we will see that. We saw that in the position statement, net zero drive, everything from the exciting concept of 20-minute neighbourhoods and planning, and using electric vehicles, the shift to electric heating in homes away from gas boilers and oil-fired boilers, right down to the power system. So the white paper that we covered earlier is clear about the massive shift to electricity use, and we saw that in just one or two of the references in the onshore wind policy statement draft about the doubling of electricity demand, and that has to be clean electricity. And I think a lot of people sometimes are under the misconception, well, what can a wind farm do to deal with emissions? Yes, they've got to, the power system has been very good about being reduced in terms of fossil fuel emissions, but the shift of society, not just to a low carbon, but to a net zero operation, will require a massive increase in renewable electricity to be provided. So we see that in the white paper, we see that in the onshore wind policy statement redraft. And I think that is really the answer. It's in those documents in terms of the link between renewable energy generation and electricity usage.
Okay, and you don't have any sense of what proportion that might be in terms of percentage or in terms of the overall solution?
Well, the UK government has said I was going to come on to that all use of electricity has to be fully decarbonised. They're looking for 2035. So it's if you look in the white paper, there is a diagram showing the electricity use, and it's the largest proportion of end use, if you like.
Okay. Okay, thank you. Council?
Mr. McTeer will come back on. I don't think there's terribly much more he wants to come back on, but you want to come back?
No, ma'am. Just I think Mr. Bell put that quite well. There's renewable energy has its part to play in that in part of the wider mix. There's no getting away from that particular point, and that's really all we have to say on that one.
Mr. Gordon?
Yes, I think, I mean, I completely agree with Mr. Bell that we need to see substantial increases to keep up with electrification of heating and transport. Mr. Bell didn't add it, but might have, since it supports his case. In the 2030s, nuclear power will cease to exist in Scotland as well, unless we go for modular reactors. And clearly, new low carbon sources will be needed to replace that as well, that baseload as well. And the Committee on Climate Change has suggested, I've got a note here, it suggested that total electricity demand will increase by 50% by 2035. I'm actually surprised at that and wonder if I've actually made a typo, because I would anticipate it might be much more than that. I'm looking to see if Mr. Bell thinks it's only 50%. I think it's higher. But anyway, I mean, we are agreed there'll be a very substantial increase. In a sense, it's not renewable energy per se is not the issue. It is acting as an enabler of the substantial economic, social and behavioural changes in transport patterns, for example, that will be needed to achieve net zero. I don't think there is, forgive me, I'm just looking back to the question. Yeah, I don't think there is a great deal of difference between Mountaineering Scotland and Mr. Bell in this respect.
Okay, that's helpful. Mr. Bell, did you want to respond?
That's fine, thank you.
Okay. Okay, so the next question, I think we have touched on that a bit in some of the answers already, but I wonder if there's anything more that you would like to say, Mr. Bell, on whether the capacity of unbuilt schemes lessen the case for further consents.
Probably deal with it quite clearly. Covered the reasons why a lot of weight can't be placed on the portion of consented developments. And I think even when you add on a reasonable assumption about what could come through from that basket of capacity, there's still a need for a lot more capacity to be consented to get to the 20.4. And I think the most powerful point on that is the onshore wind policy refresh, which is very clear that more onshore wind capacity needs to be delivered faster. The government wants the deployment rate to increase over the next decade. And the government clearly knows about the consented capacity that's there, and they caution about it. So I think that would be my reference point to answer that.
Okay, thank you. Mr. McTeer, did you have anything else to add?
Just on the subject of the policy refresh, something that I would draw your attention to is the appendix at the end, the first appendix on the subject of the seismological station at Esdalmuir, which I think is appendix. It's Annex 1. Sorry, apologies. So it's to do with the working group and the policy proposals surrounding the area there, which is something that I'm familiar with various pieces of casework over the course of the piece. In terms of the current 50-kilometre sort of exclusion zone, if I can use that term just now, around Esdalmuir, there's currently 1.7 gigawatts held up in well, not held up, but sitting in the planning system, which would account for about a quarter of the sort of the national pipeline of projects waiting to go. So there is capacity elsewhere. I know there is a working group looking at unlocking the capacity in that particular area of the country. And if we look at paragraph 14, where the government are consulting on options. So the first option there, paragraph 14, is to reduce the exclusion zone to only 15 kilometres from the test station there. So that certainly would unlock future potential in that area, which would free up some of the in-planning schemes.
Some, but not all of those schemes.
But not all. But
Yeah.
not all. No, there's obviously a balance there to be struck.
Right. Okay, that's helpful. Thank you.
I just
Mr.
come
Trin?
back as to your point, because as Mr. Patir knows, I'm also fairly familiar with this topic. The option in paragraph 14 isn't quite as he states. Let's just go back to basics to get this clear.
Okay, so let's have a look at the document, can we?
Yes, 753. I haven't got any page numbers, I'm afraid, but
sorry, just taking a minute. Okay. So page 44, is that right?
I'm sure it is.
That looks at the options, 4 options, yeah?
That's the one, yes. I mean, just backtracking, there is a statutory consultation zone of 50 kilometres by statutory instrument in England and Scotland, because this zone extends into England, around the seismological array at Esdalmuir. And the statutory consultee here is the MOD, because it's a defence establishment.
Yeah.
There has been in the past a budget for wind energy development measured in terms of vibration. We won't go into the details. That budget has at various stages since roughly 2005 been used up, opened up again, and is currently closed. It's closed because a scheme has gone in within the 50-kilometre zone, which has absorbed all the budget. And the budget was acquired not when consent was granted, but when a scoping application was made. It sounds weird, but that's the way it operates. It is. Now, what's being consulted upon is not reducing 50 kilometres to 15. It's whether there should be no-go zones within the 50-kilometre consultation zone. The current no-go zone is 10 kilometres. That has been the case since 2005. And the consultation, it's a second consultation because there was an earlier consultation, I think, when the original OWPS came out. The current consultation being repeated is what should we do about the no-go zone? Should it be extended from 10 to 15 kilometres or somewhere else, some other distance? Point being that budget gets used up exponentially faster as you get closer to the array. So budget use at 49 kilometres is very, very much less than budget use at 10 or 15 kilometres. So that's the consultation going on.
Mm-hmm.
What to me is clear, and Chris Mattia may have a comment on this, is that there is absolutely no indication of when further budget under any option may actually be released by the MOD. We have no indication of that, and anyone foolish enough to guess, I think, well, it would be foolish to guess, maybe 3 years, 5 years, 10 years, we just don't know. So that's what I wanted to say about that, and obviously this topic I very unfairly explored briefly yesterday with Dr. Swales, who gave me what answers she could, and you've seen the documents.
Okay, that's helpful. I'll just go back to Mr. McTeer first then before I go to Mr. Gordon. Is there anything else you wanted to say in response?
Not really, no. I suppose I should have caveated the 15 kilometre sort of distance. It does say that there's no guarantee that that's going to be the distance. That's, you know, presumably a working assumption that they've made with that. And yeah, I would agree with Mr. Trinick. It would be difficult to predict when this particular issue is liable to be resolved. Although from a technical sort of point of view, the wind farms at the outer edge have resolved these particular issues. I'm thinking of the one that went to Shelling Hill, which is just about finished construction. It was located about 48 kilometres from Esdalemuir, and they required to clear that particular condition with the Ministry of Defence, which they did, and I'm aware of that as the case officer for that particular development.
Okay, could I just stop you there, because I'm sorry,
Sorry.
I'm aware we're approaching 11 o'clock.
Yeah.
We're going to have a break now for Armistice Day, but I also suggest we have a short break on the end of that. Thank you. Until 11:10. Hello, everybody. Back online?
Yes, I'm sorry, ma'am. I dropped out. I don't know if I've actually missed anything. I've been out since 11
How
o'clock.
long have you been out, Mr. Gordon? Do you know?
At 11 o'clock, you were just interrupting Mr. McTierney, I think it was.
That's fine. That is the point that we stopped for 11 o'clock. So you have not missed anything. Right, is everybody back? Mr. Armstrong, I can't see yet. I'm not sure whether he's there.
I think he'll be with us momentarily.
Right. I spot him in the background. Okay, that looks like we have everybody now. So apologise, Mr. McTier, for cutting you off in the middle of your sentence there, and also that I didn't let you know in advance that we'll have a slightly shorter break then, but it was just because of the delay in starting that actually seemed like a good time to just have a short break. So if you'd like to resume, Mr. McTier, with what you were saying about the Eskdale Muir issues.
I was more or less finished anyway, but just to round off that, there is I suppose there is capacity in the system there, and I know I pointed to option 1 on the consultation. Option 2 looks to be one which would require development between 10 and 20 kilometres to satisfy the Ministry of Defence that they can mitigate the impact of the development on the array. So that's I'll just round it off there, I think.
Okay, that's fine. So we'll go to Mr. Gordon now. Do you have any comments about this question?
Forgive me, I'm slightly lost track. We are on bullet 6, the capacity of unbuilt consents.
Yes, that's correct.
Yeah. The only other thing I was going to add was that there are a large number of scoping reports being submitted to ECU within the last 12 months. So I don't think there's going to be any shortage of wind farm applications, onshore wind farm applications coming forward within the next few years, and therefore capable of being built before the end of the decade. That was the only point I was going to make.
Okay, thank you. Mr. Bell, did you want to say anything else?
Just come back briefly. It's Mr. Trinick.
Okay.
Yeah, Mr. Gordon's right. I'm sure there's lots of capacity coming forward, but if you look at the period between scoping and the consent, it averages out at 4 or more years. You've then got at least 2 years to mobilise and build. So if something is not submitted fairly quickly, it's not going to make 2030 even as we sit here. These things take a lot of time to come forward. And evidence to Bell in case she's got anything else to say.
No, nothing further on that point.
Okay. Thank you. And the final bullet under this section is more of a technical point, and I would welcome just a little bit of discussion around the operation of the battery storage. I wonder if Mr. Bell, is it Mr. Bell that could say more about that?
Yes, I'll cover that. Thanks.
Thank you.
To cover it fairly briefly, the application documentation refers to 6 megawatts of capacity for battery storage, and there's really 2 main uses, if I can use that term. One is to assist National Grid in balancing the grid in periods of fluctuation in demand and supply. Mm-hmm. And secondly, what's called ancillary support services to National Grid, such as fast frequency response, where there may be a spike in demand that needs to be met on the system, and there can be an immediate release from batteries onto the system to further balance out. And I would say for your own notes that the most recent position from the government on this is in the OWPS refresh. So there's really 3 paragraph references. The 3413, which refers to battery storage,
Sorry, could you repeat that one? I didn't hear the first number you said.
It's 3.4.13.
Okay, thanks.
Which states that the government believes that onshore wind can play a greater part in helping to address the substantial changes of maintaining security of supply and network resilience. So that's what those two elements of use would do, is to ensure that network resilience or contribute to that. Then paragraph 3.4.16 is helpful. Then probably more relevant, 3.4.17 states we've already seen an increase in onshore wind development co-located with battery storage. As we continue to progress towards decarbonisation of our energy system, battery storage will be more and more prevalent. On-site battery storage not only removes pressures from the grid, but enables more locally focused energy provision in certain cases. So, put another way, it really makes the energy generation more usable.
Sorry, you're breaking up a little bit there. Just the last minute. I don't know if it's just whether you were moving or.
I was just saying that in effect, it allows more renewable energy to be produced rather than wasted or curtailed with the battery element, which is a benefit of the development. That was all I was going to say. Thank you.
Okay. The council want to say anything on that?
No, ma'am.
Okay. Mr. Gordon?
Just to say that, I mean, Mr. Bell started off very well, and then I started to part company with him slightly just towards the end. I wish there were two different names for storage. Mr. Bell very accurately described the sort of what one might refer to as the short-term storage, the grid balancing and so on in his early comments. But what the government often seems to do is to conflate that with the long-term storage to cope with periods of low wind that might be for 1 or 2 days. Can I make it very clear? Mountaineering Scotland has no objection whatsoever to the proposed battery storage at this wind farm. We just want to be clear that it only addresses the first two types of use that Mr. Bell referred to, the short-term balancing. And just to put that into context, I mean, electricity demand in Scotland varies from 50 to 100 gigawatt hours per day. Shepherd's Rig proposes 6 megawatt hours. You know, there's no way that storage of that level is going to, for example, keep the lights on while there's a calm period. And I'm not suggesting that that Shepherd's Rig is presented in that way. I just want the reporters to be clear on that, given the way that storage is kind of used in a rather cavalier way. And let's be clear, I'm not accusing Mr. Bell of that. He's been quite precise.
Okay, thank you. Mr. Bell?
I think the only point we would make is that when one examines every development on its own, sometimes the figures seem small. But in terms of the grid, it's the overall capacity of battery storage that will become important for grid resilience. And that, as part of National Grid's plan, is to invite responses from providers that can contribute to the overall grid system. It's an integrated grid system around the UK and highly integrated, so that small developments can make important contributions when taken together across the overall network.
Okay. Okay, thank you. So we'll move now on to section 3, which is about the National Planning Framework, and obviously it's a little frustrating that we don't have the time to talk more about NPF4 draft today, but we'll just go through this section fairly quickly probably. So NPF3, we don't have any further questions on that. We've seen the sections, seen the evidence that you've provided. And on NPF4, bearing in mind that obviously we haven't had time to consider the new draft, I just wondered if we could focus on the indications of change, if there are any, in the policy approach to onshore wind farms in the position statement from November 2020, and what weight should be given to that. Could I start with Mr. Bell?
Yes, thanks. I think this is probably an area where it's difficult to be definitive at present, and everything we say will have to be caveated with the forthcoming written representations following the review still to be undertaken. But I think the key point I would say is that what we do know is that NPF3 and SPP were drafted in 2014, and they are dated and they don't reflect the reality of today's circumstances. And a lot of that new material we covered earlier in the discussion. What we do have is the position statement, and it's quite clear that front and centre of that document is net zero and the drive to emissions reduction. And that is a direction of travel. We know it's not a policy document in itself, but that direction of travel talks about rebalancing the planning system so that climate change is a guiding principle for all plans and decisions. So we will see in the written representations how that has been reflected in the new national planning policy. But it is clearly quite fundamental change in terms of the rebalancing, and that will be something decision makers need to grapple with. What I would say is that in terms of the weight to go towards that, it's inconceivable that there will not be there will be a deflection from driving to net zero, which is set in law, and the document will become statutory, be scrutinised in Parliament. Therefore, as part of the development plan for this case, it will be key because it will sit alongside the LDP of 2019, and that will have a bearing on the weight to be placed on policies that are in the LDP that are perhaps not consistent with what is in the leading change in NPF4. But that will be probably for the written submission to deal with.
Okay. Council?
I think Mr. McTeer has mainly addressed these points, but if he could just come back on one or two additional points in relation to Mr. Bell's comments.
Okay.
Yep, thank you. Yeah, I covered most of the points earlier on when we talked about the refresh and what have you. In terms of the weighting and everything else. Obviously, and I do take Mr. Bell's point that SPP was drafted a while ago now, safe to say, but you know, there's nothing superseding it at present, and obviously the decisions that we took were based on the policies that were in place at the time. Obviously, with NPF4 coming yesterday, you know, we'll save sort of detailed comments on that for our written submissions. Obviously, I don't want there to be any sort of crossover or any complications with this one, and obviously, as a council, Dumfries and Galloway Council will have to respond to that. Obviously, I'll feed into that as necessary, but I wouldn't want there to be any sort of conflict between those two pieces of work that we'll need to do for that.
Okay. Mr. Gordon?
Yes, if I can just start by observing that it's very noticeable that the Scottish Government report on catching up with the missed emissions targets, which is CD 756, actually contains no actions on electricity generation, renewables or onshore wind. Now, that's not because they're unimportant, and certainly the government doesn't regard them as unimportant, but it's because reducing national emissions is a much wider challenge. And I think, without actually making any comment on the content of NPF4, that's actually reflected in NPF4. Not every statement made in or anticipating NPF4 should be read as support for onshore wind. And in terms of weight as emerging policy, NPF4 would usually have a limited weight. However, I might get slapped down for this, but having looked at it, it contains so much continuity from SPP 2014 and as it applies to Shepherd's Rig, that I think actually much of the draft NPF4 is likely to emerge unchanged in the final policy. There is a lot of continuity.
I mean, I guess I was trying to get a view from you on the weight to be given to the position statement rather than the draft.
Oh, the position statement.
Because that's what we have, or that's what we had up until today, and obviously we've got the draft now.
I'm sorry, ma'am, I don't actually have a view on the position statement because I saw that as
Okay.
superseded by the draft. But may I just say that I think the draft policy should be given greater weight than a draft document normally would be.
Okay, Mr. Bell, do you want to add anything?
It's Mr. Trinnick, ma'am.
Sorry.
We agree with what Mr. Gordon says about the weight to be given to the draft. It may well be more because of the circumstances of its release, the fact it's been before Parliament. There is one further point occurs to me, that there is a 120-day consultation period. I don't know when you'll be writing and submitting your reports, but it's entirely possible, at least possible, that if NPF4 is finally issued, say in April next year, which I believe is the intention, that this is still will be a live application. Your reports may not quite have gone in. I don't know, I'm not guessing. But in that event, there would seem to be a need to think about further representations on the finalised document. I'm just putting that down as a marker at this stage.
That's right. I mean, there is a process there if reports are with ministers at the point, and that's happening with other wind farm cases that we have at the moment. So we'll cross that bridge when we come to it.
Yeah, it's fine.
Okay, so moving on to SPP. So the first point was around the implications of the Court of Session judgment, and obviously we now know that ministers didn't challenge that decision, so the December 2020 amendments fell. So can I have any views that you may have on the implications of that judgment on this case? Mr. Trinnick?
Mr. Bell will speak to that.
Okay.
Thank you. Yes, I think my hearing statement referred to the SPP of 2020 and the finalised amendments, but given the challenge, the legal advice I've received is that we fall back on the SPP of 2014 unamended. So we're now dealing with all of that documentation, and that includes the presumption in favour of development that contributes to sustainable development. And that takes us in turn to paragraph 29 about the principles, and that's the next item on the agenda.
Okay.
And so that would be the conclusion or the consequence, if you like, of reverting back to that SPP. That's the important point, I think, for this case.
Okay. Okay, so we'll get on to that in a minute. Anything that the council would like to say?
I suppose the only point in relation to the decision is that it obviously has already been discussed. It quashed the amendment, but it does highlight the importance of consultation and the danger of attaching weight to documents that have not gone through the whole process correctly. And I suppose that decision of the court also highlights the sort of discussion that went on, whilst it wasn't one of the reasons for quashing the decision, but there was considerable discussion about the requirement for strategic environmental impacts to be taken on board when there is any change to policy, and that the full implications in relation to changes in policy are considered before a final decision is taken on the document. But apart from that, there's nothing further to say.
Okay. Mr. Gordon?
Nothing, ma'am.
Okay. So turning to the next question then, Mr. Bell, would you like to pick up this about the principles in para 29?
Yes, I set these out in table 3.1 in my hearing statement, and these are unchanged actually from the 2014 SPP. So the same points apply. The key ones, I would say, in answer to your question, are due weight to net economic benefit, the delivery of infrastructure, that's energy infrastructure.
Do you want to give me the numbers, seeing as you've written them out with numbers in your table? That might be the helpful.
Sure.
So that's number 1.
So number 1, let me just give me a moment. Number 1, number 4, number 5, number 7, number 8, 9, and 10.
Sorry, Mr. Armstrong, would you like to say something?
It's just that it's been pointed out, I think we've lost Mr. Gordon again.
Oh, okay. Sorry, let's have a pause then and see whether Callum can bring him back in through the lobby. Just mute for a second. Mr. Gordon, are you back with us? Mr. Gordon, can you hear me? Mr. Gordon, I can see you, but I can't hear you. Are you able to unmute?
I'm sorry, ma'am. I'm seeing faces looking at me as if you're expecting me to respond. I've just got it back. I'm sorry, ma'am. In the first place, I was kicked out.
Right.
And as someone who spent his professional life recognizing patterns in numbers, I'm just noticing I seem to be kicked out every 30 minutes on the hour and a half hour.
Oh.
I have no idea. This has never happened to me before. I have no idea what's going on.
Well, I think you've been behaving pretty well, so it's not us that's kicking you out.
When I did come back, I saw these expectant faces looking at me, and but I couldn't actually hear anything. So my apologies, ma'am.
Right, so we'll keep an eye on that at 12 o'clock then, and if you disappear, we'll know what's happened.
If we're still on the second bullet point in Scottish planning policy,
we are.
The only point I was going to make, and I was actually trying to find.
It's okay. You haven't had your opportunity to speak anyway. So Mr. Bell's just running through his answer to that second question.
I apologise. I'm interrupting Mr. Bell. My apologies, Mr. Bell.
No problem. Glad to have you back. Right, Mr. Bell. Oh, can't hear Mr. Bell now. Are you on mute? That's okay.
So it's just going to finish by saying that in terms of the approach, the principles broadly followed the approach in the Gladman judgment, which I think is before the inquiry's CD 9.36, is we still look at the principles in assisting the overall judgment as to whether a development would be one that would enjoy the presumption, namely it would contribute to sustainable development. And that's what I've set out in my hearing statement. Thank you.
Okay, great. Council?
Yes, not a great deal to add on that one. Obviously, SPP is to cover a multitude of development, not just wind energy development. And I think certainly in table 3.1 of Mr. Bell's statement, I think that encapsulates all the key points for this particular development. Obviously, all the points in paragraph 29 have to suppose they have to take a holistic approach to everything. Yeah, everything needs to be taken together in the round. But I think Mr. Bell has identified the key principles there.
Okay, Mr. Gordon, now your chance to respond.
Yeah, I'm sorry, I obviously didn't hear all of Mr. Bell's comments. Simply, Mountaineering Scotland essentially looks at number 9, the protecting, etc., the landscape and wider environment. We consider that to be important, and we think it's for the decision maker to draw the balance with how all the factors come together.
Okay. Mr. Bell, anything further? Sorry, I didn't hear you.
Sorry, I'm not controlling my mute. So
All right, sorry. I'll come to Mr. Trinick. Mr. Trinick.
No, nothing further.
Okay, thank you. So the next question was around paragraph 154 of the SPP and the account to be taken of stated national objectives and targets, and to what extent you consider the SPP policy out of date given the introduction of the more challenging climate targets that we've discussed. Mr. Trinick?
Yes, I would say it would be correct to say it is out of date, and that's evident with planning policy now having to catch up with the law. We talked earlier about the legally binding target. So the government clearly took a view that the Climate Change Act wasn't delivering enough, fast enough, and the 2019 Act came into force before planning policy was changed. And so the various targets have moved on, that's a factual position. I think also from a planning perspective, SPP and NPF3 are very much concerned about moving to a low carbon society. And it's now a net zero society that the position statement references. So I think NPF3 and SPP need to be viewed from that perspective. Thank you.
Okay. Council?
Ms. McTeer will deal with this point.
I suppose the application of the stated targets has been overtaken. It does say at point 63 at the very bottom of the page that further targets may be set in due course. That does, I suppose that's the backstop in this particular paragraph of SPP, that whilst the SPP is the current planning policy that we look at in Scotland, the targets have been somewhat moved on from those that were published at the time.
Okay. Mr. Gordon?
Well, I think we're all in agreement that the targets and numbers are completely out of date. I mean, I think some of the basic principles or elements of paragraph 154 of SPP remain relevant, and I think they'll largely find their way, perhaps somewhat rephrased, into the new policy documents.
Okay. Mr. Trinick?
Nothing else.
And the next point here is around paragraph 169, looking at the development management considerations. And I was interested in your interpretation of how we apply the net economic impact and cumulative impact issues. Mr. Bell?
Yep. I think, firstly, in terms of net economic benefits, I've always taken the view that that's net additional, therefore the benefits would not be displaced from elsewhere. So just taking an example, for example, it was a retail development that was going to draw trade spend from elsewhere, that wouldn't necessarily be net additional spending. But here, the economic benefits are net additional, and I would say can be treated as such. And the hearing statement seeks to summarise what these would be in terms of employment and employment generation and capital expenditure.
I'll deal with cumulative impacts, but
Okay.
can I just seek some clarity on what information you want from us on that?
Just how we should apply those terms.
Oh, I see. Okay. Well, going to SPP 169 electronically, there is a link from the word cumulative impacts to the glossary. So at least you've got a definition of what SPP means by cumulative impact. And it's important to recognise it's not just about landscape and visual effects. There may be acoustic or ornithological or other cumulative effects. In this case, we are dealing with landscape and visual cumulative effects. You've heard the evidence from the two witnesses, expert witnesses on this. I don't think there's a massive amount of difference between them and the way they approach matters. You start by looking at the proposed development's additional effects on the operational baseline, maybe under construction. You move on to the cumulative effects in two scenarios, consented and then in planning. But then I think you also have to, very importantly, and perhaps more and more importantly, as the baseline increases, not just look at the additional effects, because inevitably they grow less as developments are added. You need to look at the overall effects of the development, the in combination effects, if you like, including the pattern of development. So I think the pattern of development comes under that cumulative effects heading. I hope that helps.
Okay, thank you. I do appreciate that we've covered a lot of that ground yesterday. Council, like to respond?
Yes, ma'am. I think we have obviously dealt with the issue of cumulative impacts in relation to landscape and visual, and there's obviously been some discussion in relation to CD 506 and the supplementary guidance, which we'll no doubt get on to discuss in section 5 of today, and the in particular paragraphs D1 to D11, which deals with cumulative impacts and the burden of cumulative impacts and the pattern of development. And again, I don't think there's any dispute between the parties in relation to the relevance of these paragraphs. And for the rest, I'll just hand over to Mr. McTeer.
Thank you. Yeah, in terms of net economic impacts, these were assessed as part of the committee report. We did look at them as additional impacts with that, and they were given due weight accordingly in my report to the Planning Applications Committee. So I don't really have anything further to add to what's already there.
Okay. Mr. Gordon? No? Okay. Anything else, Mr. Trinick?
Not from me, Mr. Bell.
No, thank you.
Thank you.
Okay. Great. So move on to the LDP then, section 5. And just a couple of questions here. Firstly, to what extent the council agrees with the applicant's view that policy IN2 is the LDP policy most relevant to this case, and that limited weight should be given to the other LDP policies in the reasons for objection. So I wonder whether I should start with the council on this, if that's okay, seeing as I'm asking them a specific question. Mr. Bell?
So, sorry.
Oh.
Just to start with on this, I refer to a number of previous cases where this question has been posed, and I thought it'd be helpful just for consistency in making to have a look at that. So it's in my paragraphs 4.3.6 to 11 in my hearing statement, but taking it short, I refer to the Cornharrow 2 decision CD 9.46, Windy Standard 3, which is CD 9.26, and Glenshimmerich, which is CD 9.47. And the quotes are in my hearing statement, but what I've taken from those decisions is that the key policy, the lead, the dominant policy, for that is IN2, and that policy adequately takes into account the other matters addressed in other policies, some of which don't have a balancing mechanism. I think that's an important point. Whereas IN2 does, it allows the decision makers to take account of benefits, whereas some of the other policies are just too rigid and don't do that.
Okay, can I just clarify those three CD references? So the first one was 9.26 for Cornharrow. What was the second one?
9.46.
Oh, 46. That's why it didn't make sense.
And then Windy Standard 3, which is 9.26.
Yeah.
And Glen Shimmerich, which is 9.47.
47. Yeah. Okay.
And the specific paragraph references I've highlighted in my hearings.
Yeah. Okay, that's helpful. Council?
Mr. McTeer will address this point, but obviously, as far as the council is concerned, policy it's accepted IN2 is an important policy, but also we've had a considerable amount of discussion about policy NE2, because part of this development is in the regional scenic area and affects the regional scenic area. Policy NE2 is an important policy, and indeed the local development plan does specifically set out that when considering the policies, one must have regard to the supplementary guidance and the key aspects of that in relation to these issues. But I'll hand over to Mr. McTeer.
Thank you very much. Yes, you'd be unsurprised to know that we don't agree that IN2 is the most relevant case in point for this particular development. In my inquiry report on page 21, I have outlined what I consider to be the important policies with respect to this at 6.3.4. So obviously the full list of development plan policies were in the report to the Planning Applications Committee. One of the points we're looking at are the council's overarching policies OP1 and OP2. They are the overarching policies within LDP2. They're the ones you come to first. They are the ones that set out the council's vision for not just for development but for everything. So the overarching policies are they are important in their own right. Particularly OP1 has certain sort of key issues which are relevant to all applications. So that's certainly the first point that I would make for that. Policy OP2, we look it's policy OP2 supported by supplementary guidance, which I think it's paragraph 2.2 of the supplementary guidance associated with policy OP2 says that that particular supplementary guidance isn't to be read in isolation. It's to be read with all other supplementary guidance, which in this instance, I would draw over to policies IN2 and policies NE2. IN2 is obviously very, very important, as is IN1. IN1 sets out the framework for renewable energy development, and IN2 obviously contains the criteria for wind energy development, and it distills down all the relevant criteria from SPP into the development plan policy. So the supplementary guidance in association with that is very important. In relation to siting, in relation to patterns of development, which is something that Mr. Trinick mentioned earlier on with that. But
can I just ask a quick question on that,
yeah.
on the supplementary guidance? So just to be clear, that the supplementary guidance that relates to OP2 is design guidance, is that correct? And
sorry, ma'am.
And the supplementary guidance that relates to IN2 is the wind energy supplementary guidance.
Yeah, policy OP2 is to do with I suppose with placemaking, but there are siting and design elements with that, and obviously in terms of it was noted, you know, that I considered the development to be contrary to OP2. There are elements of siting and design as part of the application. It was something that was covered in the council landscape architect's response. There was elements of siting and design taken into that, but I'm not going to stray into that because the landscape and visual sort of sessions are behind us, and I think everything's been covered with that one.
Okay. Sorry, so I interrupted you there. Was there anything else you wanted to say about the policy framework? Is that your?
I think that's everything that I've got just now. Yes.
Okay, so I appreciate that kind of covers to some extent the second bullet point in this section as well. So maybe give Mr. Bell an opportunity to bring that in a little bit in a second. But Mr. Gordon, do you want to say anything?
I have nothing to say on any of the bullet points in regarding the LDP2.
Right. Okay. Thank you. Mr. Bell, do you want to come back on the first and in effect the second bullet in that section about OP1 and OP2?
Yes, I just think when one looks at the terms of OP1, OP2, they are related to design quality and placemaking. That was the title, and the supplementary guidance that lies on that links to that is clearly different from the wind energy supplementary guidance. So I don't see the relevance of going into placemaking guidance when the design and siting considerations for wind are comprehensively covered in the topic specific SDG that we've got. And again, the decisions are helpful in ensuring that we've got consistency here. Cornharrow, paragraph 183 is helpful, where the reporter said OP1 and OP2 appear to be directed primarily for proposals for build development, and set out that whatever they set out as requirements, they're adequately addressed in IN1 and IN2.
Can I add to that, ma'am?
Sure.
OP2, this question of supplementary guidance, I hope I'm not get too much disagreement on this. It says supplementary guidance provides further detail on the above elements, of the bullet points in OP2. And those bullet points relate exclusively to built development or the movement of people around development, open space, landscaping, safe, accessible, inclusive places, integrate sustainable energy and design measures have absolutely nothing to do with wind energy development. So that supplementary guidance is clearly other supplementary guidance. It's not that for wind energy development. Answering a point made by Mr. Armstrong about NE2, I think that's a troubled policy. That it doesn't read well even on its own terms. I agree it's relevant. Of course it is. The RSA is in play, although I still say IN2 is the lead policy. But if you look at the first sentence, the first siting and design development within RSA should respect the special qualities of the area. The second sentence is a separate sentence. Development within or which affects, and there we do come into play. We affect the RSA, but not within it. May be supported where the council is satisfied that. So the second sentence is clearly in play, but not the first sentence. And when it comes on to what the council has to be satisfied about, the factors to be taken into account and designated in the area, but not be significantly adversely affected. I think that's incapable of application. You will remember in cross-examination of Dr. Swales, I drew attention to what those factors were as set out in the RSA document, CD 518. And none of those factors could be adversely affected. They're simply factors such as boundaries. In fact, I'll just dig that out if I may. It won't take long. If you look at these factors, they are precisely Existing and past designations, character area boundaries, visual envelopes, topographic units and transition zones. They're not sort of, you don't use those sorts of words for a development test. You can't adversely affect them. They're simply factors to be taken into account. So actually applying this policy, I think, is riddled with difficulties on its own terms. I will, though, add that if you come to look at it and you look at the second bullet point, is there a specific need for this development in our location? No, we wouldn't pass that test. I don't claim we would. There are other locations. But I don't think that policy really helps you very much. Okay.
I do feel I should allow Mr. Armstrong maybe just to come back on that, because we've gone into that a little bit more detail.
Yes, ma'am. The first point, I've got Mr. Trinick noting that the application site doesn't extend into the RSA. Well, certainly on the map that Mr. Trinick was very keen to lodge CD 11.8. And perhaps you can just clarify that to start off with. The regional scenic area is the brown lines and the brown boundary, and the site boundary is shown with the turbines on CD 11.8. Perhaps you could clarify that point before I come back on some of the other points Mr. Trinick made.
You got me back to rights. There are 3 turbines in the RSA. I surrender on that point. Quite right. The rest aren't, but the 3 are, so fair enough.
Okay, Mr. Armstrong.
Well, is it not perhaps 4? There's one certainly right on the the line. If we look at turbine 1, 4, 6, and 16.
I think we'll have to leave at that point. I would accept 2. I don't accept necessarily any more. 2 are on the boundary. Can take that view, but no, I don't accept those 2.
And Ma'am, just dealing with Mr. Trinick's difficulty with the policy, that is not a difficulty that other reporters and indeed the Scottish ministers have had with the policy, and I'll pass over to Mr. McTeer on that. But there are a number of decisions where before you that set out the approach that the reporters have taken to the policy, and to considering it, and to coming to conclusions on it.
And you're talking about policy NE2 there?
Yeah, that's right, Ma'am.
Okay.
But I'll pass over to Mr. McTeer on that.
Thank you. Yes, obviously the location of development within the RSA does, I suppose, does rather highlight the reason why we considered NE2 to be one of the relevant policies in the first place. Obviously, it's the regional scenic areas. Development needs to respect the special qualities of the area for which they were designated in the first place. This links to the technical paper on the RSAs. Now, I don't want to labour the point with these ones, but certainly as part of the submitted LVIA, the applicant highlighted that there were significant effects on a portion of the RSA, certainly in which the development was located, and you know, that just brings to light the fact that it fails the policy test of policy NE2, and why we do consider it to be one of the key policies in our decision making.
Okay.
Sorry, I forgot one point.
Okay, Mr. Trinick.
Which is that there is no balance in that policy, and I think that should be noted.
Yeah, that point. Okay.
Ma'am, if I could perhaps just also add that I mentioned some decisions. One example is the North Lowther one, CD 932, where there's a discussion of this policy on page 95, and on page 121, there there are conclusions in relation to the effect on a regional scenic area there, but there are obviously numerous decisions where that are before this inquiry where the reporters have made conclusions on this policy and have concluded that proposals are not consistent with it. And of course, the important point is it's not just the within, it's or which affects the regional scenic area. And of course, we've got the evidence over the last couple of days in relation to that.
Okay. Okay, that's helpful. The third bullet point is just a question about what you think reporters should take from the absence of policy IN1 from the Council's objections reasons. We've touched on that a little bit here. Is there anything else that parties would like to say on that? Mr. Trinick?
No, thank you, ma'am.
No. Council?
Just a couple of points. The points of, sorry, there's a bit of an echo going on. That's better. Yeah, I think the way that we've tried to structure the sort of the reasons of objections were to look at the overarching policies and the most relevant of the sort of the detailed policies. So OP1 and OP2, obviously they're the sort of the general policies. So we took those points, but certainly IN1, if I would just quote from LDP2 at paragraph 4.105. It just says that IN1 provides a general framework for the assessment of all forms of renewable energy. It is noted in my report to committee and in my inquiry report that we do consider it to be contrary to IN1. There's obviously a balance to be struck with that one, but we certainly we considered, without over-egging the decision that that IN2 was probably the best one to include in the reasons for objection.
Okay, that's very helpful to understand. Mr. Gordon? Sorry, Mr. Gordon, did you signal?
Sorry, ma'am, I was shaking my head.
All right, sorry, I didn't spot that. My fault.
I have nothing to contribute on any of the points
Yeah.
In section 5.
Okay, thank you. Council want to say anything else? Not the council, sorry, Mr. Trinick.
No, thank you. That's fine.
No. Okay. I'm conscious of the time. We've got to 12 o'clock, but we only have another question. Are people happy just to continue on?
Yes, please.
Yep. Okay, great. Yeah. And so the final question is just around the Group 3 areas and to get an understanding to what extent wind farm proposals in Dumfries and Galloway were always acceptable in Group 3 areas. Nice one to finish. Mr. Trinick?
Mr. Bell will start.
Yep, I would say they're not always acceptable. And we know SPP tells us they're likely to be acceptable, subject to detailed considerations. In this case, the development is Group 3, so we need to look at those criteria. I think it's expected that draft NPF4 will reference the further important role of renewables. Again, I don't want to stray into that, but what we do have is the draft OWPS, and it tells us, and we covered it earlier, that there's got to be greater, faster deployment. So the government wants more faster of onshore wind, and they've made clear that NSAs and national parks are the top tier for protection. We know in the spatial framework that local designations don't feature, so they are part of Group 3. So I think the NE2 policy needs to be viewed in that context. And I think having gone through the figures earlier about what the ambition might mean, is if we took that figure of 8 gigawatts of additional capacity, and if we take the view that in Scotland, there's already 8 existing. Effectively got to double that in the next 8 years. That must mean that there's going to be a greater and more widespread presence of wind energy, primarily in Group 3 areas, where that presence is accepted. So that goes back to, I think, what Mr. Trunick mentioned, I think, is a tipping point for decision makers. I think, put another way, questions may be posed that what was refused in some cases a year ago, 2 years ago, may now be deemed acceptable development. And that will be something that decision makers need to start to grapple with. And so I think the key point would be for Group 3 areas, what is that unacceptable effect that is so unacceptable that in the broad canvas of what we've explored this morning means that development should not go ahead. That is really the nub of where we are with Group 3, subject to what is in the draft NPF4 in terms of the new spatial planning approach for wind, which we'll need to explore in the written exchange.
Can I add to that, ma'am, that
Yes.
there was a point arising in respect of the SPP Group 3 advice in Table 1 of SPP, because the advice is that beyond Groups 1 and 2, in Group 3, therefore, wind farms are likely to be acceptable, subject to detailed consideration against identified policy criteria. Now, in my view, a policy means it's a policy. It's not just any guidance. Now, we have policy IN2. The Council has prepared supplementary guidance on the hook of policy IN2, which is CD 5657. The relevant regulation, I'm sorry to quote it, but it's the supplementary guidance was made under Section 22 of the 1997 Act, and the Development Planning Regulations 2008 make it clear at Regulation 27 that such supplementary guidance may only deal with the provision of further information or detail in respect of the policies or proposals set out in the plan, and then only provided there is an express hook in the plan for the supplementary guidance. I'm proceeding there. Now, in the supplementary guidance itself, CD 56, paragraph 1.1 says very explicitly the purpose of this supplementary guidance, it says it quite correctly, is to provide further detail in support of the development management considerations in IN2. So the supplementary guidance isn't some separate policy. It's only supposed to be providing further detail in support of IN2, and I would say, therefore, to be consistent with IN2. It's part of the development plan, therefore I agree it has the same weight as the development plan, and indeed the LCS is part of the development plan as a supporting document to the supplementary guidance. The key point is that the policy is IN2. Supplementary guidance just provides further detail in relation to IN2. And that's important in terms of the advice in Table 3 of SPP. That's the point I wanted to make. Thank you.
Thank you. That's helpful. I was going to ask a sort of supplementary question on that, so I'm glad that you've given your view on that. Council?
Ma'am, if I can start and then let Mr. McTeer address some of these points. First of all, in relation to policy IN2 and group 3 areas, obviously we've got the wording in the supplementary, we've got the wording in the SPP that says subject to the detailed considerations against identified policy criteria. Well, policy IN2 sets out various criteria, and we can see in the supporting text that these considerations are set out in more detail in the supplementary guidance. It's perfectly proper for supplementary guidance to set out further, more detailed criteria. And indeed, again, the consistent approach of Scottish ministers and their reporters has been to have regard to the criteria set out in the supplementary guidance. Secondly, in relation to policy IN2, on page 70, when referring to the spatial framework, sets out that provides strategic guidance. However, it must be read in conjunction with the supplementary guidance and its appendix, the DGWLCS. And so the spatial framework map must be considered in that context and that policy context. Ma'am, there is one point whilst we've been discussing supplementary guidance that I'm conscious of going back to OP2, and OP2 refers to supplementary guidance. That supplementary guidance, which is not before the inquiry, in turn refers to all the other supplementary guidance. And I think if I've correctly noted down, Mr. McTeer, he refers to paragraph 2.2 of that supplementary guidance, which in turn refers on to all other supplementary guidance. And that's why in the sort of suite of supplementary guidance, for example, the case that's most relevant to us, the supplementary guidance on wind energy, CD 506, has a section on design because it is cross-referenced and referred to in the other supplementary guidance, and it's specifically dealing with design issues in relation to wind farms. It may be helpful that the inquiry should have the supplementary guidance that Mr. McTeer referred to about 15 minutes ago, before the inquiry in the paragraph 2.2, which then brings in the supplementary guidance in relation to the wind energy.
I think personally
document.
I would find that helpful just for completeness. Thank you. So if that could be submitted.
It can. Now, I'll pass over to Mr. McTeer in relation to the more
Thank you.
General points.
Thank you. I suppose looking at the point in question that we're looking at, to what extent that wind farm proposals are always acceptable in Group 3 areas, but it's not always going to be the case, and it has been alluded to by others that they're likely to be acceptable, subject to detailed consideration. Certainly in the LDP against all relevant plan policies. I know it's a slightly different turn of phrase within SPP. So let's not forget that they do require to be subject to detailed scrutiny for other matters. Turning just to Mr. Bell's ambition about unlocking and providing additional capacity or generating capacity, if you will. I think we have seen, more widely that there are opportunities within the system, particularly when we had regard earlier to the area around Esdommuir. So there are areas where we can unlock the potential for that. They're likely to be Group 3 areas as well. But the point I just want to go back to. Actually, it's 2 points. I'll go back to just the first being that the acceptability is always defined by detailed consideration against other policies. And just if I can make a point sort of more widely about LDP2 and the supplementary guidance that we have. LDP2 is relatively recent. It was only adopted in 2019. So the way that we've set out LDP2 in terms of our umbrella of policies and the sort of the plan more generally, it has been subject to reporter scrutiny fairly recently, and that's really the sort of the last point I would make about the LDP.
Okay. Thank you. Mr. Gordon, you didn't have anything to say. Mr. Trinick, do you want to add anything?
Yes, thank you. I think I've been led a bit astray here. I'm not, whatever reporters say and whatever IN2 says, the law is the law. And Regulation 27 of the Development Management Regulations makes the position quite clear that, and indeed, the SG we have in front of us already reinforces that position. It's not the job of supplementary guidance to provide additional policies. The job is to provide further detail in support of policies, and the guidance must be consistent with the hook policy in the development plan. That is the law. And therefore, and I just give advance warning in closing submissions, when I look at, for example, D11 in the supplementary guidance in CD 5.6, where it says proposals be tested with respect to a number of criteria. These are not policy criteria. This is additional detail in support of IN2 and must be read accordingly. So far as turning to OP2 is concerned, I'm surprised the Council is maintaining this, because the wording is very clear. Supplementary guidance provides further detail on the above elements. It says it very clearly. I've already been through those elements, which have nothing to do with wind energy development. So whatever the supplementary guidance says about being read with other supplementary guidance doesn't help the Council one little bit in respect of OP2. In terms of supplementary, the reporters having looked at OP2, yes, they did, but supplementary guidance was not before the reporters. That has not been examined. That appeared afterwards. Only IN2 has been examined by the reporters for the local plan. Finally, could I just ask Mr. Matier, sorry, Chris, I didn't pick it up, could just repeat what he said about Estelle Muir, in case I need to respond to that.
Mr. Matier.
Was more a point more generally about unlocking capacity within the system. That was all.
Thanks. I don't think they were in disagreement that we can't predict when that capacity might be released. So there we are.
Okay, thank you. Right, in terms of any other matters, I had just marked down a question about the supplementary guidance and the status of that, which we've already covered. So can I just check that there's no other burning issues that people wanted to raise, Mr. Trinick? Mr.
Yeah.
Bell.
Just 2 points really. One is one of the documents lodged in the energy policy area was CD 7.47, which was the IPCC, the Intergovernmental Panel on Climate Change report. And I just wanted to flag that obviously COP26 is going on this week. There may be a statement coming out of that that is of some relevance. So I would recommend that it be considered that alongside NPF4, if there's anything that is of relevance in terms of COP26 outcomes, that could be addressed within the written submission to come. The only other document that hasn't been referred to is, I would recommend for your note, is relevant, is the net zero strategy from the UK government, which is CD 7.54, published last month. And the key point I would say that helps with an earlier question that you had about the proportion of energy needed from renewable sources. It's on page 98 of that document, where it says that the carbon budget 6 represents, I'll just read it, it's a brief quote, a very significant increase in the pace of power sector decarbonisation, coupled with an increased demand due to accelerated action in other sectors. And it says, although the white paper, that's the December 2020 white paper, envisaged achieving an overwhelmingly decarbonised power system during the 2030s, we have since increased our ambition further. By 2035, all our electricity will need to come from low carbon sources. So that's the UK position, is bringing forward that total decarbonisation of electricity. by 2035. So the page reference would be page 98 in the net zero strategy.
Okay.
That was the only other point I was going to raise.
Okay, thank you. Mr. Armstrong, is there anything else?
I don't think Mr. McTeer has got anything else to come back on. Just to respond to the Mr. Trinick's earlier comment, that I'm happy to come back with submissions in relation to his point, and just also to perhaps point out that there are indeed, I've got one to hand, decisions from Scottish Ministers' reporters since the supplementary guidance has been adopted in February 2020. One example is CD 946, but again, we can deal with that in submissions.
So can I just clarify that you're talking about adding in a sort of exchange of submissions on the supplementary guidance issue?
I'm happy to deal with it in closing submissions.
In closing, right? Okay, yeah. Okay, Mr. Gordon, was there anything else?
Nothing from me, ma'am. Thank you.
Okay, thank you. So that's been very helpful discussion. Thank you. So just to confirm that we're awaiting the submission of that map 1, or the document that includes that map 1, as we discussed yesterday, and also if I can have sight of the supplementary guidance that relates to OP2, just for completeness. So it's now 12:20. We'll obviously finished up nice and early, but we do have other participants taking part in hearing 2. So I propose that we continue with the allocated time of 2 o'clock start for that session. So that gives you a nice long lunch, hopefully. Any other questions at this point? Mr. Gordon?
Yeah, so I mean, that is the end of my participation. Can I assume that your dates for closing submissions, exchanges regarding NPF4, etc., will all be communicated by email, and my presence will not be required at the end of any of the further hearing sessions?
No, that's correct. We'll communicate that to parties, and thank you very much for your participation over the last
thank you
3 days.
Thank you for putting up with my IT problems. I note I didn't go away at 12 o'clock, so the pattern is not as I thought it was.
Good. Okay, thank you very much. Mr. Armstrong, did you have your hand up there? No? No. Mr. Trinick?
No.
Okay, right, great. So we'll see you at 2 o'clock for those of you who are taking part this afternoon. Thank you.
workings as we did it.
Callum, I wonder if you can hear me just now. It says that you're viewing, are you?
Yeah, please, what can you
Testing, testing. Can you hear me, Laura? Can you? I don't know if I'm in. Testing, testing. You can hear me. Does it sound okay? Am I clarity? Excellent. Fantastic. That's great.
Good afternoon. I'm hoping everybody can hear me. Thumbs up. Mr. Aid, you can hear me? Great.
Yes.
We're just waiting for Ms. Haywood's there. I'm presuming that the other parties are just observing, so I think everybody who's taking part is hopefully on the video now. Great. Okay, so welcome to hearing 2. Hope you've had a nice lunch and a nice break. So hearing 2 relates to traffic and transport aspects of the proposed Shepherd's Rig wind farm. So hopefully everyone can hear and see me. We've had a few technical issues this morning, but hopefully this afternoon things will run a bit more smoothly. And if there are any problems, we will just take a pause and we'll take time to fix them before we move on. For the benefit of those who were not involved in the earlier inquiry session or hearing session, my name is Rose Leaven and I'm a reporter with the Scottish Government, and I'm appointed jointly with Ms Haywood to make recommendations to ministers on the wind farm, and Ms Haywood is waving there. I'll be chairing today's session. I don't propose to repeat all the housekeeping matters again, but if you are taking part, can you please keep your video on throughout the hearing and mute your microphone unless you're speaking. And to save time when you're being asked for your agreement, if you can give us a thumbs up or a nod, that would be great. As usual, we'll be recording the session, and the webcast recording will be publicly available to view on our webcasting site in due course. Again, for the benefit of those not involved in the earlier sessions, please could I ask everyone who's taking part today to introduce themselves, starting with the applicants team.
Thank you, ma'am. Yes, Marcus Trinick, Queen's Counsel, instructed by Rad Johnson Mackenzie, but I won't really be speaking in this session. I'm already badged, as you see, as Gordon Buchan, and Gordon Buchan will be taking my seat right now.
Okay, thank you. And the council's team?
I'm Douglas Armstrong, Queen's Counsel, member of the Faculty of Advocates, instructed by Laura Whitelaw, Dumfries and Galloway Council. And there's, I'm joined this afternoon by Kevin Morrison, team leader for roads planning, the roads planning section of Dumfries and Galloway Council.
Okay. Good afternoon, Mr. Morrison. Can you make sure that make sure that we can hear you? Could you say hi?
Yeah, thank you, ma'am. Yeah, hi everybody. Can you hear me?
Yes, that's great.
Spot on.
And Mr. Buchan, we can see you anyway, and presumably we can hear you too.
Yes, hopefully.
Great, thank you.
Mute.
Mr. Aid?
Mute. Yeah.
I can't hear you. Could you just unmute yourself, Mr. Aid, just to make sure that we can hear you when you come to speak?
Yep, that was my mistake. Yep, sorry. I'm Ben Aid, yes, on Carsfield Community Council.
Great, no problem. I think we'll all probably forget to mute and unmute ourselves at some point, so that's fine. And Miss Clubb?
Yes, hello. My name is Fiona Clubb, and I'm a resident in the Carsfield community and a local business owner.
Okay, thank you. Welcome, Ms. Clubb. So as discussed at the pre-examination meeting, hearing sessions take the form of a structured discussion, which I will lead. There's no cross-examination of the parties, so it's a bit less formal. You have also circulated your hearing statements, and you should find them on your memory sticks. We've considered the evidence in all of your hearing statements for all the hearing sessions, and so we don't propose to go through them in any detail. Instead, we have circulated agendas in advance with the areas that we would like to focus on, and I hope you all have those in front of you. And as we go through the agenda, you'll all be given an opportunity to explain your position and elaborate areas of concern. You may ask relevant questions informally through me. I'll bring people in at the relevant time and indicate when we think we've got enough information on each topic. Ms Clubb also mentioned yesterday the possibility of having time to make a statement at the hearing. As I've said a moment ago, and which I should have made clear yesterday, the format of the hearing sessions is a bit different from the formal inquiry sessions, and the parties don't have to present evidence in the same way. But you will obviously have the opportunity to come in on all the questions if you do have something to add. And we also have what you've submitted in your hearing statements. Therefore, I don't think it's necessary for parties to make a further statement at the start of the session, but I'm very happy to allow you to have 5 minutes at the end to pick up on anything that you feel we've not discussed on the topic of traffic and transport. And I would be happy to give that same offer to the other parties if they felt that was helpful. So, Ms Clubb, could you let me know if you feel that that will be necessary? Yes?
Yes, that sounds good to me. I'm happy with what you've said. Thank you.
Okay, and would any of the other parties expect to make a short statement at the end, or are they happy with the discussion as it goes along? Mr. Armstrong?
Ma'am, we're happy with the discussion as it goes along. I don't think there'll be any issues at the end.
Okay, Mr. Buchan?
We will be making a statement, ma'am. We're quite content. Thank you.
And Mr. Aid? Sorry, I can't hear you again.
I don't think I'll be adding another statement. No.
Okay, that's fine. Thank you. Right, so we'll come back to you on that in due course, Ms Clubb. And we do recognise that there is a bit of crossover, obviously, between some of the matters we'll be discussing in hearing 2 and what might be covered in hearing 3 on conditions, but we should try and discuss everything at this session that we need to on the traffic and transport topic, including conditions, and that may make the agenda for hearing 3 somewhat shorter. And on that note, depending on the timings in this session, and obviously making sure that we do have enough time to let everybody have their say in this session, just to say that Ms Haywood and myself are available to carry on straight into the conditions hearing if the applicant and the council would want to do that today rather than reconvene tomorrow. So I don't know whether you have any views on that just now, Mr Trinick and Mr Armstrong, or if you'd like to come back to us during the course of this session.
Mr. Trinick has advised that would be fine with him if we could continue.
Okay. Mr Armstrong, have you got any views on that?
Ma'am, we'd be happy to do that, although there is, I know the team has got a sort of cut-off time at sort of, I think we'd agreed that we'd be sitting till 4 o'clock, and I don't think we'd want to go particularly past that.
Okay, well, I was actually meaning that we would be happy to go past that if the other parties were. So if it's a problem for you, then we can still reconvene tomorrow. But I'll perhaps leave that with you just now, and you can have a think about it. And we may have a little break at some point that you could have a discussion with colleagues on. Okay, right. So if that's all right, we will now begin the session. So as I've said at the start of the agenda, there is a bit of crossover, but I think we should pick up on any conditions issues as they arise through the course of the agenda. So the first item is actually item 2, which is the draft traffic management plan, and it was just to clarify for our benefit whether there have been any changes to the outlined traffic management plan that we saw from May 2021, which was circulated as CD 1103. Could the applicant address that, please?
Certainly, ma'am. There are no changes proposed to the outline TMP that we've published. I have, however, made some suggestions for additions to it that could be made in the finalised traffic management plan, and I've referred to those on page 18 of my inquiry statement, which is CD 011.05. if it would be helpful, I can give a quick précis of those, if that would be helpful to you.
Well, I don't actually know if we need that at this point, because I think I've got that identified under 3B. Is that correct? So it would be the measures that you've set out at 5.12.4 and 5.12.11. Is that right?
That is correct, yes.
Right. Okay. Well, we'll come to that in due course. That's fine. So any other? I take it there's no other comments on 2A from any of the other parties. No.
I was just going to check with Laura that the comments that the roads plan team had not been implemented into the outline plan. We had actually sent an email with alterations to the word in section 523, highlighting the bridges that they were going over, and asking for excluded routes as well to be included in the traffic management plan. So these were additions that were going to be added to the finalised traffic management plan, but unfortunately they're not been done at this point.
So could you give me an indication of the date of that?
That email was sent,
correspondence.
yeah, the 3rd of June 2021.
And would we have seen sight of that? Is that part of any of the evidence?
I think, no, it's not part of the evidence, no.
No. Well, I guess if there's any points that you feel that you can pick out of that letter that fit into the discussion today, then we could do that. And if there's any outstanding issues, then you might want to submit that
Yes,
letter in due course. Okay. So section 3 is about the implementation and the enforcement of the traffic management plan. So first of all, we wanted to ask a sort of general question about the council's experience and what that has been of enforcement of transport conditions and TMPs in relation to some of the other wind farm proposals in the area, including the extent to which planning monitoring officers have been successfully employed elsewhere. So could I ask, I'll just go in the normal order, which would be to ask the applicant for views on that first. Mr. Buchan?
Thank you, Ma'am. In terms of the question there about the council's experience, I mean, we'd obviously have to commit to Mr. Morrison to provide his experience of that. I have nothing really to add on that particular element there.
Okay, you might want to respond once he's made some comments. Okay, so Mr. Buchan?
That would be in order, thank you.
Yeah, that's fine. Mr. Buchan?
Yeah. Hello, it's Kevin here, ma'am.
Oh, sorry, Mr. Morrison. Yeah.
Just to let you know that in terms of the experience that the council has in relation to traffic management plans, we have obviously lots of traffic management plans for wind farms, but in terms of any enforcement action required on them, I think the nearest we could really say would be the windy standard one, not the windy standard, the windy rig application. We had some conflicts, shall we say, with windy rig. And that's the only issues we've ever had in terms of with traffic management plans and with regards to wind farms.
Could you maybe expand a little bit on what the issues were and how you dealt with them?
Yeah, sure. It was the issues in particular were to do with the delivery of AIL movements. The problem occurred.
Sorry, could you just maybe explain the abbreviations just for the other parties?
Abnormal individual load movements, and the problem being that the particular vehicle that was employed to carry out these deliveries was a slow moving tilting trailer vehicle. Basically it goes at 4 miles an hour, so it takes some considerable time to traverse the actual delivery route. And there was some conflicts with members of the public when the police were carrying out escorts along the route. So that's the kind of the gist of the main issues that were involved with the traffic management plan for Windy Rig.
Okay, and to what extent could you do anything about that? Did you mention the police there?
Well, what happened was the police were involved and they were responsible for escorting the deliveries. A couple of times I think they had to abandon the deliveries, and after which times they discussed the traffic management plan with myself, and I explained how it worked and what unrestricted meant in paragraph 523, at which times the deliveries proceeded. Sorry, could you repeat what you were saying? What was the second part of that question?
It was just to understand to what extent you could do anything about those problems.
Yeah, sure.
Either yourselves or the police.
Yeah, well, what had happened was the problems. We also had initiated a ward event that was carried out by local members and ward officials. We got the members from the community council and all affected parties. We had a ward event to try and iron out the issues involved in the traffic management plan. So there was some conclusions that resulted from that, one being communication to improve that. That was it. That was the main issue that came out of the ward event. So hence why we're trying to apply to this particular application.
Okay, and we will get time to discuss the sort of communications plan idea as we go further through the agenda. So that would be the main one. Windy Rig has been the main.
Windy Rig is the only one where I've really had an issue with the traffic management plan.
Right. Okay. Could I ask Mr. Aid if you've got any comments on maybe your experience of Windy Rig or others?
Yes. Just to clarify, Windy Rig uses the same routes that Shepherd's Rig will use. So it will probably experience the same problems. But Carsfield Community Council experienced countless complaints from residents, businesses, with all the delays and the problems with the deliveries on the Windy Rig project.
Okay.
It's finally over now, thankfully, but it went on for so long.
And could you confirm, is it mostly or only about the delays, or is it to do with any other matters?
It was the delays, the condition of the road, because they did destroy the road temporarily, which lasted for months, and damaged. I work as an engineer, and I had to replace people's spare wheels regularly because everyone's elderly around here. So I'd get call outs because they go through potholes that were created and subsiding bits of road. They have now rectified all that, but you know, we had to put up with that during the course of the wind farm build. But the delays were extreme. Yeah. I experienced that firsthand, and also we received many complaints from different people to the community council.
Okay, that's helpful. Sorry. Yeah, sorry, Miss Haywood would like to.
I just wanted a question really for local residents, but also for Mr. Morrison. Coincidentally, when Ms. Levin and I did our first site inspections to this area, we were stuck behind one of the lorries for Windy Rig as well, and it did take an awful long time to get around. But when that particular lorry was a tilting one, the blade lorry, the one that was very slow, and there was no police in evidence of that one, where we were stuck behind it. So I just wanted to ask Mr. Morrison if they were supposed to escort every single load like that, were they?
Yes, they were. It should be notified through the proper procedures. Right. And the police are obviously part of the escorting, and that's recorded within the traffic management plan as well. So yes, they should.
Yeah. And so what do you think was the problem with Windy Rig? Why did it? I know obviously it was a particular trailer that they chose to deliver their components, but why was it so much more difficult for them than it has been for all the other wind farms that you've dealt with?
You've hit the nail on the head there. It was the trailer which took all the time to deliver the components. That obviously means that there's less roadworks to do because the vertical geometry and the horizontal geometry it's easier to get round. But on the offset to that, it takes the vehicle itself a considerable amount of time to get to site, and that's the issue. Notwithstanding that we did put in passing places to hopefully allow that were permanent, allow the likes of forestry vehicles and other vehicles to sit in while the vehicle went by and attempt to mitigate against the speed of the vehicle. But I do concede that it was the speed of the vehicle was the main factor in causing the delays.
Okay, thank you. Ms. Clubb, would you like to come in on this point?
Yes, I'm not quite sure where to start on this one. I've written some bits and pieces out here, primarily against this first comment about the council's experience of the transport issues, and particularly with the fact that why has this happened in this area and it hasn't happened before. I think it's something that needs to be discussed. And I come a little bit here from experience because I've lived in another wind farm community before I came to this one. I used to live over at Auchengray in South Lanarkshire. It's Muirhall Wind Energy were doing a lot of works across there. So I have experience of transport difficulties with the type of trailer that Shepherd's Rig are proposing to use. So I can compare my experience of Windy Rig with what we experienced before. At the time we were operating a call-out service, emergency call-out services for HGVs. And we did at that time, even with the smaller trailer, the ordinary trailer, not the lifting ones, we experienced difficulties in negotiating their own traffic management plan and their communication system, even with the fact that these ordinary trailers do go a lot faster. There are still a lot of problems associated that businesses have to cope with. The reason why I am kind of pushing this a little bit is because, yes, Shepherd's Rig are talking about using ordinary trailers, but there's no guarantee that they're not going to ask for bigger turbines once they get permission. And if they need bigger turbines, very likely they're going to start to move towards this new technology. So we have to be prepared and have this discussion with respect to the road network around Carsfairn, which is extreme in the sense. So why has this happened here? That's the question, and not elsewhere. And really, the road network around us that we're talking about, the B729, the B7000, the 35S, the Milton Park Road, I can't remember the number, it might be the 49S, with this 51S, well, there's a whole lot of the network around this area. We're talking about overgrown, twisty, narrow roads between grids. A lot of them are floating roads. They're very lengthy. We have very lengthy diversions if any of these roads are blocked. I mean, sometimes it can be hours it takes us in terms of diversions. There's cattle grids, there's animals grazing on them, there's passing places, we've got tourists, we've got livestock, bikes, horses, cyclists, the Southern Upland Way. This is a kind of a route that goes from Dumfries to Ayr that a lot of people use. This is not a dead end place. This is actually quite a used route for people passing through. We've got some serious winter black spots. And we're pretty low down the gritting agenda. So with all this increased traffic, then the roads get hard packed, we get ice, we get all sorts of problems. As we know from the two cranes that tipped over in the local area, the road was totally unfit for, well, both incidents, the road was totally unfit for purpose. They should not have been on those roads. Why were they on those roads? Windy Rig, of course, said nothing to do with us. They were just coming to us. But that's a very reductionist approach to running their operation. Of course, in terms of legally, they're not going to take responsibility. But at the end of the day, it's their build, and we as a community live in this place, and we take a holistic view of our environment. If the road is blocked in one way, we have to go in another way, and that causes us lengthy, really long diversions along very substandard roads. So the thing about this area is that there's a lot of business going on here. You might drive through and think, well, there's nothing happens and this is a deadbeat place, but it isn't. It isn't. We've got logging lorries, we've got timber equipment transportation, we've got haulage businesses, we've got livestock services, we've got a lot of shepherds going in and out with loads of sheep. We've got a hay delivery, straw delivery business. We've got Tesco, all these delivery people coming in, DPD and all the couriers coming in from Amazon because everybody's locked in. So there's a huge amount of traffic that's using this whole network. Not just the little strip from Carsfairn that goes up to the Shepherd's Rig entrance. It's not about that. It's about the effect of the knock-on effect of what happens in the whole area and what happens to us as residents and businesses when we get blocked in. We've got residents, a lot of residents who are care workers. We do have a lot of retired people, but we've also got a lot of people who have jobs that they have to go out to, including care workers. And we do have a situation with Windy Rig where we have a child who had to be dropped off for the school bus, and the school bus got blocked in by the wind turbine, and the child had to just be abandoned at the side of the road in the middle of nowhere. That is just totally and utterly unacceptable. The parents were terrified as to how they were going to get to pick up the kid from school. These things are just horrendous to think about. So the problems that we had were extreme, absolutely extreme. And I'm suggesting that this is because of the nature of the road network is perhaps quite unusual. I could compare that to the likes of the Windy Standard Complex, which comes off the 713 and goes straight onto its own road, which takes it up into the hills, you know. And of course, the people in the 713 are impacted, yes, but not to the same extent, because once they're off road, then they're off road. And there's perhaps the other wind farms that have been getting put up. It's not the same difficult road, quite as difficult a road network as we have in the area.
Okay.
So that's really what all I've got to say about that. I think it's this particular road network that is very, very unusual.
Yeah, that's helpful to understand the context a little bit more. Could I just perhaps go back to Mr. Morrison for a second, just to ask about the extent to which, it's the second part of this question really, the extent to which planning monitoring officers have been used elsewhere. Is that something that you've got experience of?
No, unfortunately not. I've done a little bit of research on that, and we are aware that the reporter has applied a condition to Troston Lock, which is west of Moniaive wind farm, for the application of a planning monitoring officer. And having had a quick look online as well, I think the Lord wind farm, there is a planning monitoring officer against that. Notwithstanding, again, there's plenty of Council Shetland, Argyll and Bute that have used it, but me, myself, no, I've had no direct involvement with dealings with a planning monitor officer.
That's fine, that's useful. Mr. Buchan, did you have anything to add before we move on to the next question?
Yes, if I may, ma'am. Just to reiterate that the blade lifting trailer is not being proposed for the Shepherd's Rig project. Okay. It is going to be delivered using conventional style trailers. There's not a proposal to use a blade lifting trailer. And the route that is proposed is purely from the A713 onto the B729, and it does not include areas where there were the two crane incidents on that route there.
Okay. Could I perhaps, I'll come to you in a minute. Well, yeah, actually, we'll go to Miss Clubb now, actually. Yep. Do you have an additional point?
Yes, I do. And it's a very, very important point, Mr. Buchan. It's really in response to you saying that Windy Rig is only, Shepherd's Rig is only going to use from the A713 up to the entrance. I understand that's within the policy. Unfortunately, Windy Rig had the same policy that they were only going to use the road network from the A713 up to their entrance. Okay, now that's policy. That's not what happens in reality. In reality, we had lorries everywhere and relentlessly for 2 years. Commuters, lorries. They just went wherever they wanted, including across the Hight Bridge again. So the problem is that it doesn't matter what's in your policy and what's in your plan. People don't do what they're told. That's the fact of it. And at the end of the day, the residents here and the businesses here are the crash test dummies. We're the ones that suffer because basically the plan sounds good on paper. It's great, but it just doesn't work. And that the traffic management plan from its ARCIS, its traffic is fantastic. When I first saw it and read it, I thought, this is great, because I've experienced this before. I thought, this is fantastic. This is going to work for us. We can get on with our work. Windy Rig can get on with what they're doing. I didn't object to Windy Rig. I've got no grudge against it. But the trouble was that they didn't follow it. If they'd followed it, it would be perfect. We wouldn't have had this conversation. There was nothing wrong with it. It gave the residents the right of way so that the residents could move over or the wind farm could move over, and then we just pass and on we go. Simple. It's really simple, but so the message that I want to convey, and I can't say this enough, is that the map is not the territory. There's a difference between a policy and what happens in practice. And we as me as a resident and Ben as a community councillor will understand that. This is where we live and we experienced what happened with Windy Rig, and it was horrific. It was really horrific. It was. We'll talk about that later in terms of the communication plan, but I'll stop there.
Yeah, okay, thank you, Ms. Clubb. I mean, I think there are a number of points in the agenda where we will continue to talk about enforcement and how we can ensure that the measures are enforced, but we're also needing to talk about some of the measures that need to be put in place. And so on that basis, I was going to just jump ahead at this point to talk about subsection G here, which is about the blade trailer, seeing as we have discussed that a few times already. So I wonder whether the applicant can kick off by saying something about whether we should condition the type of blade trailer. Obviously, you're saying that it's going to not be a tilting one, but is that something that should be conditioned to give parties a bit of comfort about that? Obviously, if the third-party land agreements that might be required to widen the road are not forthcoming, would the developer later shift to some sort of lifting, tilting trailer? So could you give us your views on that, please, Mr. Buchan?
Certainly, thank you. The planning condition on a blade lifting trailer, I think, would be certainly the applicant has expressed a view that they would have no objection to having such a condition developed, and that's maybe something that could be discussed later today, if should you wish to. I think the wording of that condition, however, would require quite a lot of careful consideration, and especially defining what a blade lifting trailer is. Now, the blade lifting trailer that was used for Windy Rig was a Goldhofer FTV 500. Blade lifting technology and trailer technology is developing at a very rapid pace. There are a variety of different types of blade lifting trailer and technology that are being developed or currently in use within the continent. They vary from the Goldhofer system, which was used for Windy Rig, all the way through to the Kometo type trailers. There's a German firm, Schroeder, developing a trailer. And they are the types of trailer where the blade tip is elevated and the blade itself is supported at one end. But you do get hybrid trailers where there is a combination of an existing type of trailer where the blade is elevated, not to the same types of angle, not getting up to the 60, 70 degrees, but you would get up to an elevation with a blade tip of around about 10 to 11 meters. And that's a hybrid trailer where the blade is supported at both ends. Now that is a much faster moving type of trailer. A lot of the new blade lifting trailers are able to move at a faster speed than what was used for Winnie rig. So I think it would be quite an awkward condition to draft in that regard, because not everything is going to share the operating characteristics as what has been experienced previously on the road. I think it is worth noting that Windy Rig was the first use of a blade lifting trailer within the United Kingdom, and unfortunately with new technologies, then people are unused to it, are not familiar with its capabilities, and certainly from what I understand is that the first deliveries are slow, but they did speed up over time. It is in its infancy and technology is improving. I think the other thing to consider is if you are going to think about a condition, there may be other areas along the route, for example, coming out of the Port of Ayr, where blade lifting trailer potentially may be required if there is a change in the port access arrangements there. So it's not just simply looking at anything in isolation of just around Carstairs. There needs to be consideration of the route in itself as well. So I think it needs careful consideration if such a condition was to be considered.
Okay. Could I ask the council's view on that, please, Mr. Morrison?
Yes, ma'am. In terms of conditioning the specific type of trailer for the delivery of the blade components, basically from the roads kind of angle, I do think it's kind of unreasonable to put a conditioning in stating that. I think there's adequate means to kind of deal with whatever type of trailer the client or the applicant decides to use. So from the roads and the council's perspective, I wouldn't like to see a condition, or I wouldn't prefer a condition.
Okay.
Thank you.
Could I ask Mr. Aid if you've got any comments on that? Sorry, I can't hear you, Mr. Aid.
I'll learn in the end.
Yeah.
Nothing specific, but I just don't think the roads are fit for such large machines here. That's all there is to it, really. But nothing else.
Okay. Ms. Clubb, do you have any comments?
Yes.
Specifically on this issue about
yes,
conditioning, yeah.
Yes, absolutely. In terms of the blade lifting trailer, it absolutely makes sense to do it that way. And it certainly saves chopping, chopping up the verges more than necessary, and and it was very impressive to watch it. The issue was the speed. The speed of it was horrendous, and yes, it did improve, but the length of time went from, instead of being 4.5 hours to go from A to B, it was 3 hours to go from A to B. And the big issue isn't the fact that you're stuck in a lay-by waiting for it to come towards you, which, and the lay-bys were put in, the passing places were put in so that if you were coming towards it, you could sit in the lay-by for perhaps 10, 15 minutes, 20 minutes and wait for it to arrive. The issue was that if you were coming in the same direction as it, you were stuck behind it for 4 hours. This doesn't seem to have computed.
And that is what happens to us. That is what happened to us, Ms. Clubb. Not 4 hours, I have to say, but we were stuck behind it for ages.
Yeah, some people were stuck for 4 hours behind it, and you have to ask yourself, where does the emergency services come into all this? So, to be honest, I don't care what sort of trailer they're going to use. You use the trailer that does the job as efficiently as possible. But the important thing is that if somebody is stuck behind this, that either it's going at a reasonable pace, it doesn't have to be going, we're all used to getting stuck behind things that are slow. You put up with these things, but 4 hours to go, it's like 6 miles, is ridiculous. So in terms of these passing places, what should have happened was that the passing places should have been of a sort of length that when the queue got built up behind for perhaps 20 minutes or something, people will you know, that the whole rig could move over into a particular place that they could pull into and then let everybody go past, and then people can get on with their lives. But that didn't happen. And of course, what you said that you didn't see any police cars, and the reason why that was is because they're all up the front. The police cars were up the front to make sure that people would go into the passing place at ahead, but there was never any police cars at the back to tell people at the back what was going on. So that's basically all. So all I'm saying is that if you're going to put passing places in to allow residents to get on with their lives and businesses, then make them big enough for the whatever trailer it is that you're pulling, that they can move over so we can get past when we're behind them.
Okay, thank you, that's helpful. Mr. Buchan, did you want to come back on any of those points?
No, ma'am.
No. Okay, thank you. So we'll move on to question B. So, oh, sorry, Mr. Armstrong. Yeah.
Ma'am, if the council could come back on really the sort of two last points about the passing places and whether it would work, but also on perhaps one way forward, and that's in relation to notification. So if Mr. Morrison could perhaps just come back on that in light of what's just been said.
Sure.
Yeah. In terms of the passing places, if we were to have built the passing places to the size needed for the delivery component vehicles, it would have meant that there would only been maybe one or two locations where that site, which would be appropriate for the site to be built. And instead of maybe cutting your hours down from 3 to 4, you still have only maybe 2 opportunities along the whole route to pull the vehicle in. So it would still cause a delay, and substantial delay. So it was, I concede to Miss Clubb that the fact that we from the rear there is an issue and they should have pulled in. The idea was that when they spotted somebody, there should have been a banksman. They should have pulled allowed enough space for them to pull into lay-by and get by. But the way to overcome that, I think, is to maybe look at a VMS sign at the junction with the 713 and the 719 to inform the local community
What does
council.
that stand for, Mr. Morrison?
Vehicle messaging system sign.
Okay, thank you.
And it was basically to inform them that there is a abnormal load on the road and now expect delays, and it's like a road closure. You can choose an alternative route if you need to. And some of the routes aren't so long. You can use the C. You can go down towards Dalry along the C30, the 49, Carminnels and back in again, and that's maybe it's only another 2 or 3 mile extension on the diversion.
Okay, I'll allow Ms. Clubb to come back in with a quick point before we go back to Mr. Buchan.
It's not that simple. And this is what has been psychologically extremely damaging for those of us that are trying to operate our lives around this. Even if you've got a VMS sign at the end of the road, you've got to know when it's actually left, because by the time you get to Carminnels, if you do go down by the Carminnels Bridge and you make that decision, you've got to go like the clappers to make sure that you get across that bridge before it arrives, because you've got no idea where it is on that section of the route. And if you miss that, then you've got to go all the way around by Dalry. Or even if you need to go somewhere, you've got to go all the way around by Fingland. The detours, you're continually chasing a moving object. It's psychologically horrific, and it really messes with your mind. But we'll come on to that with the messaging beforehand. But what I wanted to make one point about the passing places and your response to that, and it also relates to the police and what I've said before about the fact that there was no police cars behind. So ideally, what should happen is there should be a police car at the back and a police car at the front. The police car at the front stops the people, make sure they go into passing places. The police car behind lets the police car in front know that there's people behind that need to pass. There may be an emergency behind and it needs to pass. There wasn't police cars behind. There was only police cars in the front. And behind there appeared to be a great stream of construction vehicles. Everybody was from Statcraft or RJ McLeod or Investors or whoever they were. So there was nowhere that, even if you're stuck behind, that you were going to be anywhere near the blade. It was like it was like an entourage, so the sort of thing that a queen would have, a parade. Now, the problem is that on occasions, there's plenty of opportunities, particularly at the B7000, and there are certain places where it was quite possible to pass. And there was no way in which as a motorist, that you were able to inform the police, look, we've got an emergency or we need to get past. I know we've been sitting behind you for 2 hours, but if you just pull over in this section here beside the B7000 junction or a little bit further on, if you pull them over, you will, please can we get past? And in fact, on one occasion we went out and we came up head on to them and we spoke to the police about this. I'm not talking about this because I'll talk about this in the police section, so I'll come back to that. Okay?
Okay.
Thank you.
That's fine. Okay, thank you. So back to Mr. Buchan, if you would like to pick up any points on the passing places or the vehicle messaging system, for example.
Thank you. I would agree with Mr. Morrison. I think a VMS set of signs at strategic points along the network would be an excellent idea. And I think the key thing with the traffic management plan is that these are not documents that they're written and then that's it. They should be live documents, and certainly what we're very keen to do is to learn the lessons from Windy Rig, incorporate that into the finalised traffic management plan, and then continuously monitor and enforce that as well, so we can deliver improvements to the operational elements as the project proceeds.
And did you have any comments specifically on the passing places issue?
I think on passing places, we do have experience of other parts within the United Kingdom where you can have the operational traffic management to allow trailing traffic to pass in safety, as well as accommodating oncoming traffic as well. So that can be included within a more robust and detailed TMP.
Okay. Okay, thank you. So we will move now on to, so that's items A and G that we've really dealt with. If we can go on back to B, which Mr. Buchan, you were going to take us through the additional measures that were suggested in your hearing statement, CD 1105.
Thank you. I mean, the comments there are in CD 11.003. I'll not read them out, ma'am. They're there. We believe that they're an enhancement, learning some of the lessons from Windy Rig, and you know, obviously invite the council to comment if they think there would be an improvement to, in addition to what's already proposed.
Could I ask a couple of specific points then, and then we'll get the council's views? So in 5.12.4, bullet 4, is this related to the proposed condition for a transport monitoring officer that's been put forward?
Yes, so the bullet point 4 there, when I was drafting that, there wasn't a suggestion of planning monitoring officer, but that is in effect what that role would be. Yes.
So, well, there's mention of a planning monitoring officer, and there's also mention of a transport monitoring officer. Are they the same thing?
They would be the same thing. Yes.
All right. Okay.
No, they're all different people.
Are they different people?
Apologies.
No, it's okay.
So under 3A, we talk about planning monitoring officers, but when you get to your bullet 4 and the additional condition that's been suggested, it was a transport monitoring officer.
So Mr. Trinick here,
Yep.
I better come on the microphone.
Oh.
Can you hear me now?
Oh.
That's only what but we're having real microphone difficulties. So.
Oh, I'm sorry. We can. Do you want to pause or?
Right. Can you hear me now? I
can hear you very well. Yes.
Yes. The transport monitoring officer and the planning monitoring officer are two different people.
Okay.
I think you received 2 suggested conditions last week. One relating to community liaison, the other being the transport monitoring officer.
Yeah. That's helpful. I just wanted to clarify that that's what I understood. There were 2 separate things.
Yeah, 2 separate things.
And 5.12.11, bullet 2 there, is that talking about the community liaison group?
Sorry, could you just repeat the bullet number? Sorry.
So it's 5.12.11, bullet number 2. Is that really talking about this community liaison group?
Is it or not? You've got to tell me. I haven't been in.
Yes, it would be a group to advise stakeholders and have communications.
So that's what has been proposed as an additional condition number 1. Is that correct?
Is that right?
Yeah.
Yes, that's correct.
Yes, that's correct. Yes.
Okay. And bullet point 3 under that same paragraph, so 5.2.11 bullet 3, that again, that's referring to the transport monitoring officer, is that correct?
That would be somebody within the applicant. So the officer monitoring the operation of the TMP, I believe, would be separate to the applicant. This is somebody that the applicant would appoint as a single point of contact.
So that's not the transport monitoring officer, that's somebody else within the applicant's team, is that right?
Yes, that's correct.
Okay.
And we feel that would be helpful as a single point of contact.
Okay, can you just pause a second till I take a note of that? So. Okay, that's helpful. So I'll go to the council now to get some views on, or sorry, do you want to say more, Mr. Buchan, about any of those measures? No?
No.
Okay.
No.
Could I go to Mr. Armstrong or Mr. Morrison?
Ma'am, yes, Kevin, Ian Morrison.
Okay.
In terms of the points raised, the additional concerns on point 5.12.11, there's a whole host of kind of points there. So there's some comments I'd like to kind of address and raise with that. If I can go and through them individually, it might be.
Okay, hold on, I'll just
sensible.
get that up. So that is CD 11
003, yeah.
003 5.
So that's the 003 is actually a traffic outline plan. So sorry, this is the comments from CD 011.005, page 18. Yeah. Sorry, my mistake.
No, that's fine. Okay, I've got that now. That's fine.
Yeah. So like the council have had a look at this and we've got some comments. I think if I could just kind of discuss them with you, that would be beneficial. So the first one is adjusting the site access to physically guide existing traffic to turning left. The council are in agreement with that. That would make it physically impossible for any of the traffic to take the wrong route and lead to possible blockage and any kind of routes that were alternative routes that were required, they would be free. Yeah, so we're happy with that particular point. The creation of a traffic management group, including stakeholders, that again, yes, it's the comments. It's related to the communications comprehensive communications plan. So we want to link that into that so that the traffic management group communicate with the appropriate members from the community to be able to kind of mitigate against the issues raised in the traffic. So we're happy with that.
And that, can I just stop you there? So that is the condition that's been proposed as the community liaison group, the additional condition 1. So
yes,
you're happy with the format of that? That,
yes, if we could have, we could sort that out. Yes, that would be brilliant. Yeah.
Okay.
So a sole point of contact for the TMP, who would have the responsibility to implement. Yep, again, it's back to the monitoring officer again, the planning and monitoring officer, that would take care of that particular thing, and it would.
Sorry, I think what Mr. Buchan was just saying was that would be a different person from the monitoring officer.
Right, in which case that doesn't cause any concerns for roads. It would be over and above the planning and monitoring officer, and the traffic one would again, it would just be fulfilling the same objectives in terms of communication and make sure that everything was working and there was no delays, etc. So that's fine. A vehicle identification scheme, that's commonplace. So for in terms of the using excluded routes that we'll go into later, then we have a means by we can identify this and deal with the culprits. So that's perfectly reasonable. Contractual clauses to enforce the kind of misuse of these routes. That's happy. I'm happy for Mr. Buck and that to deal with that, and that in itself should be go some way to kind of prohibiting misuse of excluded routes. So I'm happy with that. Voluntary blanket temporal traffic regulation orders. Unfortunately, I've spoken to my colleagues in another section of the road service. That's not something that we would put in place. So the temporary traffic regulations, we would have to kind of omit that from this.
Okay.
Yeah. Use of GP trackers and HGV vehicles to review adherence to the access routes. Again, that's similar to the point raised before. Happy for that to be in place. Again, that's a mechanism for enforcing that they stick to the prescribed routes, so we're fine. Wheel cleaning at the site access. Yes, mudding the road is an offence, and the police deal with that. So yes, there is a directive which we can apply, and that would be fitting. Yes, regular toolbox is a standard thing. So any new contractor on site, happy for them to be given all the details in terms of a toolbox talk for the driver etiquette and behaviour. So that's perfectly reasonable as well. The enhanced signing package across the network. I think they're maybe looking to put in proper signs in terms of the TSRG, which is the Traffic Signs and Regulations and General Directions 2016. I think that's a wee bit overkill. We don't want a preponderance of all these signs. I'm happy to have reflectorised signs in the form of temporary signs to kind of indicate to drivers and provide kind of informal speed limits in locations. That needs to be kind of bottomed out a wee bit and just make sure that we're not going overkill with that, especially in the rural location. Yeah. Sorry. The special AI operational signs to advise on movements, that goes back to the point which I raised about the VMS sign. I think, as Mr. Buchan alluded to there, maybe a couple along the route which could give indications and linked into the communications plan, it would probably be beneficial. So I'm happy for that to go in. The use of a Section 96 agreement standard place, yes, we would be looking for that to be put in place beforehand. That's a definite, yeah. Measures to address the needs for non-motorised users and cyclists. I really wanted to know how that would be accomplished, monitored and reviewed, because there's no details on that whatsoever. So that needs to be expanded a little bit more. The provision of an AI contingency plan, I understand that, and I would happily promote that. Again, we need to know a bit more details about how that's going to work and that before we can commit to that. A detailed review and management implementation plan. Again, that's attributed to the planning and warrant officer. So again, that's not a problem. I agree with that particular statement as well.
Okay, that's a helpful run through. I'll just give the other parties a chance to comment, and then we'll come back to Mr. Buchan to allow him to respond to any of those. Mr. Aid? Do you have any comments?
Nothing to comment on this one now. No.
Okay, thank you. Ms. Clubb?
Just to reiterate that, all these suggestions are great, but most of them just relate to policy. They relate to, this is what we're going to do. And that's not the way the world works in reality. The reality is it doesn't matter how many bells and whistles you put into your policy. People do what people do. And if they want to go from A to B, then they go from A to B. And they actually quite like the challenge of getting away with it. We've seen that. We've seen that to our detriment firsthand. And really, there has to be something out there that we can take this policy, which is tremendous, and the Windy Rig Transport Management Plan was tremendous. It was tremendous. It's just not reality, because that's not the way that people live. These guys that are commuting to the wind farm, that bring in the raw materials, they've got a job to do, and they've got busy lives, and they just go where they want, no matter what how many people are out there to photograph which ones are going the wrong way. We had that situation where people were getting stuck on the High Bridge of Ken, and somebody was stuck, and she was stuck behind it. She took a picture of it and sent it to me and said, "Look what's happened today. I couldn't get to my work because somebody was stuck on the High Bridge of Ken." And I put it onto some social media site, and then you start to get people, out to get you. The whole idea of, oh, let's put on some signs onto the vehicles so that the locals can shop all the bad wind farm workers, because they're all going the wrong way. It doesn't do anything for this community and the coherence. This is a very small rural community, and we need to stick together. We need to get on with each other. We don't need all this council wanting us to spy for them so that we can find the people that are going the wrong way. I don't know what I don't know what the solution is. I really don't. But I was nearly killed by one of the lorries going the wrong way, and so I'm quite passionate about this, and I'm happy to talk about this, but only if you want to hear the story. It is quite an important story, but because it relates to toolboxes and all that. So I do have a lot to say about this, but I'll be quiet just now so you can move on.
Yeah, well, I think we understand that the concerns are focusing a lot around the enforcement of whatever plan is put in place. So I appreciate that. Okay, I think we'll go back to Mr. Buchan and let him maybe respond to some of the points that Mr. Morrison set out.
Thank you, ma'am. I mean, in terms of just the enforcement there is a step improvement with what we're suggesting for Shepherd's Rig with the sign of the access junction, which Mr. Morrison has alluded to. We also have the GPS tracking as well to counter anyone taking alternative routes that are not approved. In terms of just very quickly on the other measures, in terms of enhanced signage, it would be to place signs a bit higher up off the ground, have them on a more semi-permanent fixture so that they don't get blown over by the wind or get obscured by growing grass or the vegetation there. And in terms of the speed limit, it would be voluntary for the construction vehicles arriving on site to travel at a lower speed. It wouldn't require a TTRO or anything. It would be something controlled by the contractor through the balance of plant contracts there.
Okay, thank you. So that covers point 3B, I think. If we could move on to C, which is the experience of the council being notified of and agreeing remedial works for major defects arising from the construction of wind farm developments. And we understand obviously that there is a process for that, but I just want to understand the extent to which it is considered effective. So Mr. Buchan, do you want to say anything about that to start off?
I think, ma'am, it'd be better coming from Mr. Morrison first.
Okay, Mr. Morrison.
Thanks, ma'am. Yeah. In terms of carrying out remedial works to the routes and any damage to it, there is a members of staff involved in the contractor who daily check these routes, and we also, as the council, have members of staff who periodically, I think it's once a week, travel the routes to check it, and it's under the terms of the well-maintained, well-managed highways 2016 for safety inspections. So yes, you do get defects on these routes, but it is deemed that they're not major, or when they are major, they get dealt with. So in terms of communication between myself and the contractors or the client, we'll have a good working relationship, and any reports of customer reported defects are dealt with expediently as well. So in terms of,
could I ask if there's been any, have there been any sort of major defects on that route in relation to Windy Rig?
I would say that the nearest that we came to a major defect would be the cranes going off.
Yeah.
One of the cranes wasn't on the route, it was in the B729 on the opposite side of the route. which actually was a diversion route if you want for anything on the B729 for this, which caused some issues. But there was one that went off in the C35 Lord, but it didn't damage the actual structure of the existing bituminous road. It just damaged the road widening part of the road. So there wasn't any there wasn't any delay, shall we say, to the forestry or people on that road. And that would be the only major structural damage that I've encountered on any of these kind of wind farm routes.
And in terms of the process for sort of fixing it, how long does it take to fix that sort of problem if it's been identified?
Yeah, sure. It depends on the nature of the problem, but that particular issue, it took a bit of time because they had to build a platform in order to get another crane in to lift it out. So without actually delving into it and looking at it, the actual works itself are pretty quickly, but the process is going forward and dealing with it all, getting another crane down, doing the abnormal routes for it, it probably is about a month, to be honest.
Right.
Yeah.
Okay. That's helpful, just background. Okay.
Yeah.
Sorry, was there anything else you wanted to
No,
see
just
on this?
so there are, as I said, there are safety inspections. There's a weekly inspection from the member of staff up there, identifying, keeping an eye on it, as well as any customer reported defects. So there is a robust system in place to monitor the condition of the road, and if we need to carry out any defects, which they would be carried out to the appropriate specification and standard as well.
Okay,
monitoring that as well.
I think I'll go to Mr. Aid and Ms. Clubb to make some comments, and then I'll come back to Mr. Buchan. Mr. Aid, could you make any comments?
Yeah, I would say the crane incident was completely down to inappropriate workmanship on the road widening. I'm no expert, but with common sense, you can see what they did was they dug out the original side foundations of the road, which are hundreds of years old, and they poured in small aggregate, which is completely the wrong way of doing it. You have to put large stones in first, and then you pour in the smaller gravel. But I don't know if it was to make it easier or quicker, they poured in small aggregate, and then the crane went straight through the road when it pulled onto the side of the widened section. But that could have been avoided if it had been done properly.
Okay.
And then we had to drive on because the road was subsiding and cracking, they put these temporary metal mats on the road, which were there for months. And I remember at one of the meetings, Kevin Armstrong said that was normal procedure, but I've never had to drive over them for any length of time. It was really quite rough on the cars.
Yeah, we've certainly experienced that as well. Okay, Ms. Clubb, is there anything you wanted to add?
Yeah, so obviously Ben had a lot of experience of the one up the Lorg Road that tipped over. It was fairly near to where he lives. And I was severely impacted, and my business was severely impacted by the crane that went over on the B729, which was just about a quarter of a mile from my property towards Money Ive. Now, there's this tremendous desire to say that one was nothing to do with Windy Rig because it wasn't on the recognised route, and this is where I have a tremendous difference with what is being said, because as a resident, you know, and watching all these lorries going wherever they like, that crane should never have been on that route. Should never have been there. And the fact that it tipped over because it was in the wrong place, you know, somehow it's no longer part of the problem is preposterous. Now, we were already constrained as we deliver hay and straw throughout Dumfries and Galloway, and we were already considerably restrained towards the Carsfairn end because of these 3 to 4 hour journeys of the blades coming in, which played absolute havoc with our delivery times. And then all of a sudden, our only other route out towards the Money Ive direction to our customers there was suddenly blocked by this other crane that had gone over into the bog. and we were unable to go out that way for 2 months. It was two months that it was closed off in our busiest season, and we were in a position where if we were to deliver to people in the Mony Ave direction, then we had to basically take an absolute massive detour, negotiating the blade once more across the High Bridge of Ken and then up towards Mony Ave. So instead of a customer in Mony Ave who we would deliver hay to, instead of taking 10 minutes, we were talking about an hour's round trip, an hour to get there and an hour back. So it's this massive detour. So I just want to say, I don't want to hear it being underplayed. I can't say enough just how damaging it was, what happened.
Okay, thank you very much for expressing that. So we'll give Mr. Buchan an opportunity to come back on that, and then I think we'll have a short break after that, because we've been going for a little while. So, but Mr. Buchan first, and then okay, we can go back to Mr. Armstrong. Mr. Buchan.
I have nothing else to add, Mom.
Okay. Mr. Armstrong?
Yes, if Mr. Morrison could come back on just some points that Mr. Abe made.
Okay. Sure.
Yeah, thank you, ma'am. Yeah, just to get back to the kind of points that Mr. Abe made in terms of the kind of suitability of the road widening. It was actually myself that was dealt with the road widening in the local office at that time. Excuse me, and we did carry out extensive trial pits, peat testing, road design under the DMRB, and we also used triaxial geogrids, which were designed by Tensar. So to say that it wasn't designed properly, I'm a wee bit perplexed about, because I can assure you that the actual design standard for the road widening, and it's all on the planning portal, was designed to the appropriate standards in the DMRB. Thank you.
Okay, thank you. That's helpful. So I propose that we take a short break now, just until 3:20, just to give people a little breather, and then we'll come back, and I think we'll be moving on to 3D at that point. Okay, thank you. If you just turn off your microphones and your cameras at the moment. Thank you. Good afternoon, welcome back. Everybody there? Great. Everybody hear me okay? Can you give me a thumbs up? Yes, good. So we are now moving on to question 3D, and that's about potential cumulative transport issues. How can they be avoided or limited in order to reduce disruption to residents? And, you know, as part of that question, whether the applicant can give any indication of the timetables of other schemes using the same road. It sounds like the Windy Rig movements are now complete, but it'd be interesting to get a bit of feedback on that. So perhaps Mr. Buchan could start.
Thank you, Ma'am. I mean, in terms of cumulative issues, I mean, they can be controlled with a variety of different kind of methods, and in part, it is self-enforcing, as the construction of the sites are reliant upon supply chains, for example, concrete, ready-mix concrete and aggregate. So there is a natural supply chain limit that could supply as well. In addition, cumulative component deliveries for abnormal loads cannot coincide. There is inadequate police resource to escort more than one set of abnormal loads down one corridor per day. So there is a self-limiting element there anyway. You could have a thing like a cumulative traffic or transport management plan, as was proposed in the Mid Wales conjoined inquiry, where sites are built in sequence to ensure that their peaks of construction activities do not coincide. But I don't really think that that phasing is entirely appropriate here, as I understand there's, in terms of consented sites, one other site is consented on the B79 corridor, and that is currently proposing an alternative means of access to their site. So I am aware that there are other developments considering alternative access options, but they are quite early in the planning process and have not got even close to final submission yet, let alone determination. So I think we can only look at what is consented in that regard with regards to transport. I think that, however, future developments in the area will need to consider Shepherd's Rig in their cumulative assessments because of the place that Shepherd's Rig is currently in the planning process, and especially if consent is granted. So therefore, it would be reliant upon them to consider cumulative impacts within the proposed developments there, and perhaps planning conditions on those future developments would be should be imposed rather than anything retrospective onto Shepherd's Rig.
Okay, thank you. Yep, thank you. Mr. Morrison.
Thank you, ma'am. What Mr. Buchan said makes perfect sense. There's not really anything that I would like to kind of disagree with there. What I would highlight is in the initial planning application, there is an environmental impact report, and there is a section 15.8 within that, which does assess the cumulative effects for the wind farms. And again, if there isn't a likelihood, which I've not come across, there should be a cumulative effect of vehicles. It would be incumbent upon the applicants to speak to the planning authority in consultation with the roads authority and mitigate that. So that we would put restrictions on one or the other or both to make sure that there was no issues caused by the movements of vehicles.
Okay, so in terms of what's happening at the moment and what's got consent, is there any sort of crossover with any other schemes at the moment? So
not at the present time, but as Mr. Buchan said, there is potential further down the line that we might get a little bit of a crossover with one of the proposed sites in the future. And again, I'm aware of that, so it would come to me, and because I'm aware of it, I could mitigate against that as well.
Okay,
So when you say you mitigate against it, what exactly is it that you do?
Well, then I would be looking at the traffic movements for both. I'd be looking when they were deployed, and I would make sure that there was no clash and that there would be a certain volume of traffic on and it wouldn't interfere. And again, we're linking into another communications plan so that not just only the community speaks with the applicant, but they all speak, because we have a lot of forestry in those roads as well. So we need to speak to forest managers as well. So it would just be adding another party into that conversation. Thank you.
Okay. Yeah.
Another question for you, Mr. Morrison. The Windy Rig construction traffic, that's all finished now, is it? There's no more to be done?
Yes, the restoration works have been completed as well. So the whole construction phase of that wind farm is done and dusted, and the offset works have been restored as well. And the remedial works to the damaged road are all carried out as well. So that's completed, yes.
Okay, and then the Cornharrow wind farm that has been approved, what's the access arrangements there? Not in detail, but roughly.
Sure, no, that runs down to Alan Gibbon Bridge, comes up a small unclassified road, which will need some work on, and it comes out to the junction of the B7000. A new junction will be designed there, runs along the B7000 to the C51 Lochinvar junction, goes along the C51 for a portion, cuts onto the U141 Finland Road, and that's the route for the Cornharrow wind farm.
Okay, so it's not the same as this one then?
It's not, no.
Okay, thank you.
Okay, Mr. Aid, would you like to comment?
I was wondering if Kevin knew if any of the lorries for the Yukon Head Lorg wind farm will be travelling up this route as well, because I remember looking at the plan and it said that they might be bringing some lorries in from the same route as well as the Afton side. That's also up this way, that wind farm, and it's being consented.
Mr. Morrison?
So that was for Cornharrow you're talking about there, is it?
No.
All right.
No, Yukon Head, the Lorg wind farm.
Yes, I think there's a proportion of the Lorg wind farm coming up, and then I think they're going out the opposite side onto the Windy Standard one. So there's an in-out system, I believe, on that. Yes. So there would be discussions, but that's at a future date, and we don't know if that's even going to be a cumulative effect, because that's a bit further down the line as well.
But that one has permission, that's right, isn't it?
I believe so.
Yeah.
And so just to be clear, the log route is going to use the same route as this one, or some of it that way? You got your hand up there, Mr. Buchan, I can see.
Sorry.
Mr. Buchan, do you want to comment?
Yeah, no, sorry, I got two mice in front of me and I was obviously had the wrong one. Too many mice in the hand. Just if it would be of assistance in terms of LORG, in terms of the abnormal load assessment, and that element I can speak for, having assisted RWE with that process, is that all abnormal load deliveries for that route are coming in from Newcomnock and down the Afton Road, and that there is no other route proposed for abnormal load traffic. The site does have consent, however, they are currently under consultation for changing the turbine envelope. So hopefully that's of some assistance.
Okay, so so yeah, we're not clear on that position then in terms of when that might happen. Okay, Mr. Morrison?
Yeah, just to add to Mr. Buck as well, I agree with the abnormal indivisible loads, the routes that are there, but in terms of concrete pours for the foundations, I think there's scope for them to come in from the C35 Lorg Road and go out the other way. It's not definite, but there is a potential there for an accumulative effect, and that would be dealt with appropriately.
Okay, thank you for the clarification. Ms. Clubb, would you like to come in?
In terms of Cornharrow, the blades, yes, are supposedly coming in by the Finland Road, but that's not the construction traffic is proposing to come up the B729 and across the Smittens Bridge, and even, you know, that's the way that they'll come through Mony Ive and they'll come over the Smittens Bridge, and we know that because we were told that when we had our cows between the grids that we would have to move our cows off the road so that the wind farm could come through. So we approached Energy Contour about the fact that Cornharrow wind farm was going to severely restrict our access out of our property and our business in delivering the things that we deliver. And we were told, oh, well, you know, that'll be discussed after we get planning permission. And that seems to be the way of it. That seems to, you know, it's like no care for the people that live next to you. So in terms of Cornharrow, it's a nightmare for us. They're basically going to close our business down. We're going to have traffic coming from both directions. We're going to have blades coming from the Mony Drive direction, and we're going to have construction traffic and all the paraphernalia coming from the other direction. That road is particularly, it's a difficult road. It's a floating road. There's going to be major problems. Nobody's consulted us over it as a business. And you know, it's seriously concerning that a small business can be wiped out. So I'll not say any much more about that. But what I would like to say is that in terms of the cumulative effect, as I've said before, this is not just about the narrow area that on the policy says that the wind farm traffic is going to go from A to B to the wind from the main road up to the entrance. The reality is that it's the whole road network that is affected, because if people have to get around these blockages, then they've got to use the whole road network in the area. And within that area, we're talking about Glenshimmeragh, Troston Loch, Cornharrow, Weatherhill extension and upgrade. Windy Rig is now completed, but Windy Rig we had with Shepherd Rig, Quantons, Lorg perhaps. Even Longburn. Longburn's still got its mast up. Longburn is still an active company. We're waiting for them to come back to have another punt at it. So we're very aware in the community of what's going on. As soon as that mast comes down, then we can rest at peace, but that mast is still up. So that's why I keep that on the list. Longburn's still there. So if you work that out, all these different wind farms that are all trying to have either been given permission or whatever, I think it's about 8 there. So it takes them 2 years to build these wind farms. So cumulative, even if they're all back to back, you're talking about 16 years of disruption to the community. And then it all starts again because they want to make them bigger and they bring in new ones and they've got a new design. You know, they've got to keep this industry going. You know, so in terms of this community, it's kind of finished. As Ben he hit the nail on the head. This road network is not suitable for these projects. And unfortunately, these projects have been passed. They've been consented. And as a result, in terms of running a business within this community, particularly of the nature that I do, I run a haulage business, it's finished, it's over. And we're just crippling along now, doing what we can. But you know, my husband and I, we're in our, my husband is over his 60s now, and I'm approaching 60. It would have been nice if as a woman I could have retired at 60, which is what we were promised, but not. We've got to go till 67. And we had got to the point where we had built up such a good wee business that we were now able to employ young people. And it's a very tough job that we do physically. And it would have been lovely to be able to say to the Carspain community, hey, look, we've got a job here for a youngster. It's a really good little business here, and to grow that and to invest in it. But we cannot do that because the trust in terms of how the whole planning system works around this has gone. It has gone. And you know, so basically the cumulative effect is killing this community. And I'm sure I'm sure they'll survive it somehow because they'll adapt. But in terms of my ambition to for rural redevelopment, for rural regeneration, I'm very entrepreneurial, and I'm interested in rural regeneration. It's over really in terms of what I can do. So all I'm trying to say is that there is a massive and damaging cumulative effect with respect to this particular road network in this community.
Okay, thank you, Ms. Clubb. I mean, that kind of takes us into question E here, which is, and it does sound like there is still going to be a few crossovers of different developments, even if it's not the abnormal load route, it will be the construction traffic. So I'm just wondering, under question E, where there are different developments, different developers using the same access road, what mechanisms can the council and the applicant employ to make sure that any damage that is caused is attributed to the right party and, you know, the remediation work carried out? Maybe Mr. Morrison first?
Yeah. I was just going to add on to the fact that most of the concrete pours take a 3-month period. So for all the construction phase does last 2 years, there is a small portion of that 2 years, 3 months, where you do get an increase in usage by concrete vehicles. We have got an idea from the EIAs when these are likely to occur, so that we can mitigate against the cumulative effect. From that area up there now, I think there's no likelihood at the present moment, of there being an cumulative effect from AILs or concrete vehicles. There are a couple other wind farms and coming off later, not the different sizes. So again, because it's a small period of 3 months, if we need to, we can stagger that and explain to them that they can't run at the same time. So we would apply that, and part of the TMP, we would look at both TMPs, and we would make sure that was a condition of the TMP, that there was no cross-border running at the same time. So there is a way to deal with that. Thank you.
Okay, and in terms of this specific question about damage that's caused by different parties when there's more than one using the same road, how do you approach that?
Because we separate them and we don't allow them to travel at the same time, we do apply a Section 96 agreement in place, where we do have a baseline survey of the roads to basically determine the condition of the road. It's carried out with joint client, applicant and council representatives, and we also record on a spreadsheet the defects, together with preparing a high definition visual survey of it to give us a baseline, after which times we can go back and look at it, albeit that it's inspected periodically as well again, so that we have a baseline and we can carry out remedial works and put it back to the same standard. So each time there's a new applicant on and there's a new delivery, the same process happens again, and it's the local office that carry that out.
Okay.
Can I just ask a question about that, Mr. Morrison? I have experience in dealing with wind farms the other side of the country, at Crystal Rig in East Lothian, East Lothian on the borders, and we had a session I was dealing with a wind farm there, and we had a session like this where the council was involved, the applicant was involved, the community council was involved. The community council was saying there's so many wind farms in that area that what actually happens is, they have all these agreements, but what actually happens is, because they're going out one after the other, the roads actually never get repaired, because there's no point repairing the road now because so and so is coming along next week. Well, is that a sort of situation that you have here?
No, I think, as Mr. Ben alluded to earlier on as well, I'm sure Mrs. Clubb will admit, the roads have been totally resurfaced. The C35 was actually resurfaced fully, and the major amount of works were carried out in the B729, and that was just part of the restoration works and remedial works for Windy Rig. So it is the case that we're on the ball and we make sure that they carry out the repairs expediently as well. So they're done. Thank you.
Okay, Mr. Buchan, would you like to say anything?
I have nothing to add on that.
Okay, Mr. Aid, would you like to add anything?
Well, the only way I can see of minimizing the impact of cumulative kind of effect is not to allow consent of too many wind farms in one dense area, which is what's happening here. There's just far too many applications going into one small area with small roads and a small fragile community. If they all go ahead, it's just going to shut down. It'll just be a wind farm industrial park, really. That's all.
Okay. Ms. Clubb, did you want to add anything?
I must say something about what Mr. Morrison has said there. And yes, I will admit that the roads have been resurfaced, but that's within the context that they were hellish for 2 years. And in Ben's Road up the Lorgan was like covered in in mats. It was ridiculously awful, really. But I must mention something, because there's an awful lot of people speak to me about this, and personally it's not something that bothers me at all, but it bothers a lot of people in this community, in the sense that what's happened is that there's a lot of earth being put back onto the edges of the road, you know, to put the earth back on where they were dug up to extend the roads. This is on the section from Smitton's Bridge down to where past Mordrocket Wood entrance. And of course, the road is too narrow for the traffic that's there. I mean, we still have a lot of, although the construction's finished, we still have an awful lot of what I would call commuters coming in and out, and we suspect that there's perhaps people commuting from the Money Ave direction, where perhaps with the accommodation up to, they're still going up to Windy Rig, or they're going to South Kyle. Perhaps they're going to South Kyle because that would be the route that they would take. But there's still a considerable amount of traffic, and of course the logging lorries as well. So basically what's happening is that the verge is getting totally churned up with the earth all over the road, and Ben will understand exactly what I'm talking about here. And there's some people are very, very upset about it. It's an absolute blooming mess. And I do understand the issues with the council and needing to have verges, but it might be worth taking a look at the mess and saying, right, okay, the logging lorries, you can see where the road's too narrow and where people are just churning up the verge. And it's very obvious where there's a need for another passing place at that point. There's kind of a massive pinch point there. And in some ways, because the logging lorry guys know where the hard standing is underneath the earth that's been put on top, they're saying, sod it, we're going to cross there because we know it's all right. And so they're actually showing you where there's a need for more passing places. If that could be inspected and somehow managed to maybe put a wee bit more hardcore down so that there was an extra passing place there, then that might be something positive that comes out of it.
Okay,
just a suggestion.
Okay, I mean, I appreciate that's not directly, it's not a result of this proposal. So if Mr. Buchan could just be patient, I would actually like to ask Mr. Morrison about that again, just in terms of understanding the processes for dealing with that sort of problem should it arise.
Yes, there's basically, the first thing is, there's two ways to look at this. The first thing is it is an offence to cause mud in the road under the terms of the Road Scotland Act, an offence, and if there is mud in the road, then the police should be involved. They're the enforcing authority and they can deal with the culprits. The second thing is, it has been restored, yes, but what was I going to say? The timber lorries, the culprits that are carrying this out, can be contacted from our South of Scotland Timber Transport Officer. So if there's anybody in particular that's causing issues, we could get the details from them. We can raise that with our colleagues in the Timber Transport Forum, and we can make sure that the companies, the haulage companies for the forestry, look at it and deal with it appropriately. It's not the only place it happens. It happens a lot in Estelmuir and a lot of other places, so it's not new. That's how we would go about dealing with the damage caused by forestry vehicles. Thank you.
Okay, that's helpful. Mr. Buchan, did you want to add anything?
No more. Thank you.
No. Okay. Thank you. So, well, we'll move on to the role of the police. This is question 3F, and obviously the police are not represented here today, but just to get your understanding from some of the different viewpoints here about the extent to which police have been involved in relation to enforcement. So again, I think I'll maybe start with Mr. Morrison.
Yes, thank you, Madam. The police obviously are the enforcing authority. So first of all, when we get the traffic management plan in, we actually consult the Police Scotland, and they have a communication with us, and they put their side on what they think of the traffic management plan. In terms of kind of what is their involvement and how do they enforce the traffic management plan, they're the lead escort. They're the only people that can deal with that particular aspect of the delivery. They take the lead, and once they are on, they've got complete control over the delivery of it. So if what's happened in the past along Shepherd's Ridge, they deem that it can't go ahead, then they have autonomy to deal with that and say stop. So as far as the police are concerned, they are the overarching authority in enforcement in enforcing the traffic management plan and the aspects that are involved in the traffic management plan. Thank you.
Okay, and so I mean I understand that they would enforce particular problems with the abnormal route issues, but in terms of the other issues in the TMP, in terms of damage, or you've mentioned mud on the road, things like that, to what extent are the police getting involved in
the mud on the road? We actually haven't actually got to the stage where we needed to get to the police to deal with it. That would be the case of last resort if we had to go down that line. There's been cases where there's been kind of granular material on the road for some stuff, but they've got a sweeper on site and they've used that to clean it up. So had they not done that, then we could have used the police as an enforcing authority to make them do that and deal with it that way. We've not had to get to that stage, I'm afraid.
And is it the case that they've not been involved in any other issues then, other than the abnormal load route escorting?
Yes, that's the only kind of issues that where I've had the police involved. Yeah.
Okay. And can I just clarify? That's you haven't asked them to be involved in anything else, and they've declined. It's just that they haven't.
No, they haven't
been asked.
We haven't required their assistance.
Okay. Okay, Mr. Buchan, have you got any comments on?
Not really, ma'am. I mean, the police's involvement here is purely on the escorting the abnormal loads. Yeah. Just echoing Mr. Morrison's point. Thank you.
Okay, Mr. Aid, would you like to add anything on this?
No, well, apart from one point, on the few occasions when the police wouldn't let us out of the road here, we had to wait for hours for the things to move, the large lorries. They didn't seem to have any control over what was happening. I said one time with them, I said, can I just drive a bit further and then pull into a lay-by to let the lorry pass? And they said that's nothing to do with them, that they're just told to hold the traffic. So I don't know how much control they have over the loads moving, but that's all.
Okay. Ms. Clubb, would you like to say anything at this point?
Yes, we actually spoke to the police a few times to try and figure out what the best way forward was. Basically, they had heard of the traffic management plan, but they hadn't actually read it themselves. So obviously Police Scotland have been given the traffic management plan and they've approved it and says, yes, this sounds good. But it doesn't really filter down to the guys that are actually in the patrol cars as to what this is all about. They just turn up and say, right, off we go and pray for the best. And we at one point were coming towards them, and we stopped to see what the situation was, and they didn't seem to be able to understand what it was all about. But when we said, look, but there's this traffic management plan, and they sort of read it and then they said, oh, right, okay, well, there's nothing we can do about that. We can't force you to move over. We're not entitled to do that, to ask you to move into a passing place. We're supposed to move into a passing place, but we can't do that because it's too big. Our feeling is that they're not there to enforce the traffic management plan. They're there to ensure that the developer and the blade is allowed to break the traffic management plan. That is what the truth is. And even although once we moved into a passing place and the blade went past, and when we came up behind them, they knew we were coming back. We said, look, we're going to be going down to Carsfairn and we're going to be coming back up with our lorry. It would be, you know, we really need to pass. You've read the traffic management plan now. There's a big area at the 7,000. By the time we come back, if you stop there, we'll get past. But of course, there was no policeman behind because the two patrol cars were up front, so they had no idea when we were up the back and needed to go past. So the police are there to ensure that the traffic management plan can be nice and flexible. That is the truth of it. You know, we're told that the traffic management plan is live. Yes, it is live because it can be switched off when necessary, and that is the ugly truth of the situation, and why yourselves as reporters were stuck behind it.
Okay. Thank you. Would Mr. Morrison want to come back on anything there? I see Mr. Buchan's got his hand up as well. Mr. Morrison?
I'll let Mr. Buchan go first.
Okay.
If that's okay. Thank you.
Yeah, sure. Mr. Buchan?
Thank you, Ma'am. I was just going to come back and say, in terms of information filtering down, that's why we put in the toolbox talks that will apply to everybody attending the site, to make sure that people are aware of the traffic management plan, they're aware of what's required, what's expected, and to make sure that information filters down. And I think it's just another example of how the plan can be improved and adapted from what's happened in the past. Thank you.
Okay, thank you. Mr. Morrison?
Yes, thank you, ma'am. Yeah, I'd just like to add that yes, I think there was initially some misunderstanding on behalf of the police and how to interpret the traffic management plan. I subsequently spoke to one of the inspectors at Cornwall Mountain Dumfries, and I did explain to him and clarify any misunderstandings, and in which case it was quite clear to the police what was involved and what was required from them. Thank you.
Okay. Thank you. Okay, the next question I think we've dealt with earlier on in the agenda. I'd like to move on to H, which is the question around whether the applicant and Ms. Clubb support the council's suggested condition requiring a comprehensive communication plan. Could I go to Mr. Buchan first?
Thank you, Ma'am. Yes, and suggested text has been circulated under reference 16.9.
Okay, and Ms. Clubb and Mr. Reid, if he wants to comment as well. Mr. Reid, do you want to come in first, actually? Just to keep the normal order of things.
No, I'll comment afterwards if possible, but nothing to say right this second.
Okay, sure. Ms. Clubb.
Yes, communication plan. We had a communication plan, which was through text messages. And then we had our ward meeting, and it was agreed that the communication plan of the text messages would be improved. But it didn't work.
Sorry, can I just clarify, was that in relation to Windy Rig, or is
Yes,
that in relation to this proposal? Yeah, Windy Rig.
No, it's in relation to Windy Rig. The point I'm trying to make is that it doesn't matter what plan you have. If people don't follow the plan, then it's just like a fantasy novel. it's just wishful thinking. There has to be something that actually works.
Sorry, I interrupted you there, but you were saying that there was a communication plan with text messages, and then,
Yes.
sorry, what happened
Yes,
after that?
well, the situation was that we would be told that a blade would be leaving Carsway and Laydown Yard at, say, 10 o'clock. And therefore we as a business had to go through some extremely complex mental calculations to work out how we would get our hay deliveries out and what route we would be able to do that. And so the last thing that we needed was to be able to meet head on, so we could go over the various bridges. The trouble is that there are some very narrow bridges and difficult bridges. The High Bridge of Ken is very narrow. You know, so we can't take our HGV lorry, for example, across any of these bridges. We have to go down the B729 head to head with any deliveries that are coming in, Shepherd's Rig included, whether it's what blade it is, or if we're coming back in behind the blade, then we have to be aware that that it's going to be a certain amount of time. It's a very complex calculation. So when they say that we're going to be leaving at 10 o'clock, then we have to work out how long it's going to take for the blade to come up to the High Bridge of Ken, the metal bridge over the Duke. And then we say, right, if we're coming out Carsway at that time, we'll have to go that route, and if we're a bit longer, then we'll have to go all the way around Baldalrai to get back. And of course, it's extremely difficult for us because we're delivering hay in the middle of winter. We've got the weather to consider, whether the product's going to get damaged with the rain, or we're going to get stuck in a shower or whatever. So it becomes very, very complex. Now, the fact is that they declared that they were going to be leaving at 10 o'clock, but life's never like that, you know, and I understand. I was a transport coordinator for 7 years, so I understand the difficulties. I really do. I have so much sympathy for the developers and what they have to go through. But things always happen. The police don't turn up, or something breaks down. There's always something, and very rarely did they leave at that time. So we would have our whole business day organised around them leaving at 10 o'clock. And suddenly we would find ourselves stuck because we didn't know, we had no idea if they had left at 10 o'clock. We set up a kind of internal chain through people in the community. So I had to send a message to my friend in Carsway and, hey, has it left yet? Has it left? And she lived beside the Laydown Yard, so she could look out of her window and say, yes, it's left, that's fine. The whole thing was ridiculous. So when we got to the ward meeting, it was suggested that they would let us know when they had left, but that never quite worked. It never worked. The whole thing just became ridiculous. So whatever communication system there is really has to be tried out. Everything has to be tried out beforehand in order, because this construction is not just something that happens over a few weeks and then we all move on. You're talking about 2 years, 2 years of disruption. So that the people need a little bit more consideration as to how they manage this, because I just can't say it enough. No matter what plan you put together, the people out there will do what they like. And in terms, and I will say this, I must say this, because for the crane that went off beside us, and the council closed the road, they put up their barriers. It was very firmly, do not go through here, do not drive over this piece of road that has been dug out. And what all of us obeyed that. We always didn't go that. We had to, for quite a long time, to deliver hay, we had to go all the way around by Dalry. It was an extremely long detour. But what the Windy Rig contractors did every night, and we watched them because we could see them out of our window, they drove up past the Cornharrow entrance, they dismantled the road thing, and they went straight across the the construction site where they were putting in the new road. And they thought it was all right, and they just leave it all open. And every night I would go down and I would reclose it, and then every morning they would come and they would open it all up again. And it's kind of annoying when you're trying to obey the regulations and be a good citizen and do these detours, and the people that have messed it up are just blatantly flouting, what a decent citizen would do. So eventually everybody said, and other people in the community were aware of this, they said, sod it, we're just going to drive across these roadworks as well. So all I'm trying to say is that, all I'm trying to say is that it doesn't matter what you do, whether you put up signs, whether you have a toolbox, people will do what they do. And at the end of the day, as Ben said, this road network is not suitable. It's not suitable, and that's why people are just going crazy. So,
okay, so I mean, I think about this specific question, I can take from that you probably agree with the principle of having a communication plan and a condition that would require that, but it's really what you're saying is it's really about the details of that and how it's enforced. Yeah.
Yes, that's right. That's
okay.
Yes. I mean, all these plans are fantastic. I love them. I love the toolbox. I love all that, but it's that void between what's policy and what happens in reality, and you know that's there's a gulf there that needs to be somehow filled, and I don't quite know how to do it. And it's quite easy to do that in some circumstances. If you take the examples of the roads going up to Windy Rig, I don't know if I've said this already, but a couple of years ago, or 2 or 3 years ago, Natural Power asked the council for planning permission to put in a new road up to the Windy Rig complex. And the reason for that was that they couldn't get on with the forestry developers and the hydro people up there. The three organisations could not agree how to manage their traffic on their own private road, which is basically a dual carriageway. So, you know, so they asked to put in a completely new road. It's difficult, you know, I get it. I was a transport coordinator. I understand the difficulties of dealing with people. So that's really all I want to say.
Okay, thank you. I'll just stop there for a moment because I'm conscious that Mr. Armstrong mentioned that the council people may not be available after 4 o'clock. Could you just confirm if we're able to carry on at this point?
Yes, ma'am, we are, but I think that there's one member of the team's got to be away before 5. So yeah, I think we should be able to get this finished.
Is that Mr. Morrison, or is Mr. Morrison still?
No, it's not
Hopefully we'll be finished by 5.
Yes, yeah.
I think we'll just need to carry on for a little bit longer at the moment, if that's okay. Is everybody else okay to carry on just for a little longer? Yeah, okay, thank you. Right, so I'll turn back to Mr. Aid there to see if he's got any comments on this question about whether you would support the comprehensive communication plan and that being a condition on the consent.
Yeah, better communication's always better. I think a lot of the problem last time was down to the thing which I hadn't even considered, the fact that you can't deliver wind farm components when it's windy. So it's constant cancellations. So I would plan I'm a self-employed engineer, so I book work in advance, and obviously we'd have the text messages, and it seemed a good communication from the team at the last, Windy Rig wind farm. I assume is going to be similar to Rig's plan, but because if it was windy on the day though, they had to cancel last minute, and then that means I then have a day where I have to cancel my work. This happened so many times. I lost out on a lot of money, and a lot of other residents did as well, but a lot of them just don't know how to voice their concerns. I mean, myself and Fiona are involved with this meeting, but there's so many people that just don't know how to voice all the problems they experienced, and it'll obviously happen again because it's the same kind of situation with Shepherd's Rig. But that's all I have to say on that.
Okay, thank you, Mr. Reid. Would Mr. Buchan or Mr. Morrison want to say anything else on this point? Mr. Buchan?
Thank you, ma'am. It's in terms of the wind delays, that's something specific to the blade lifting trailer, or not for a more conventional type of trailer, which is what is proposed, the shepherd's rig.
Okay, that's helpful clarification. Mr. Morrison, anything else?
Yeah, no, thank you, ma'am. Just to basically point out that yes, we did have the ward meeting and the ward event, and that was quite close to the comments being made on the TMP here. So the implication or the implementation of any changes to communication plan, didn't get the chance to put them in place. So that's something that will be taken forward, and with the possible condition of a comprehensive plan, I appreciate all parties concerned, and it is the council's aims to work together and make sure that everybody's happy with it as well. So that's all I'd like to say in that. Thank you.
Thank you. I wonder if this might be the time just to say a little bit more about these two proposed additional conditions from the 5th of November. So the first one is the community liaison group, which kind of ties into some of the discussion we've just had there. Do people have that condition in front of them? People aware of that? Ms. Clubb, do you have that? So that was, can I get their reference? So it was 2 additional documents that were submitted after the USB sticks went out. So it's reference CD 1609 is the additional conditions from the 5th of November. Do you have that, Mr. Aid and Ms. Clubb?
Sorry, I don't have that access just now.
That's okay. I could actually read it out if that's helpful. The first proposed additional condition is relating to a community liaison group, and it says that prior to commencement of development, a plan for the establishment of a community liaison group shall be submitted to and approved by the planning authority. Second section of it is the community liaison group plan shall set out provision for the group to act as a vehicle for the community to be kept informed of project progress should it wish to be so informed, and in particular to allow discussion on the provision of relevant transport related mitigation measures as set out in the TMP. It also says the community liaison group plan will provide for the maintenance of a community liaison group should the community wish such a group to be set up, until the wind farm construction has been completed and is fully operational. And it also says the community liaison group plan shall be implemented as approved. And the reason for that proposed condition is to minimise interference with the safety and free flow of the traffic on the local and trunk roads, and to minimise adverse impacts on residents and local businesses in the area. So I appreciate you haven't had you haven't had a lot of time to consider that, but I wonder if you have any thoughts on that proposed condition. Now that came from the applicant, so I will ask Mr. Morrison to comment on whether you've got any comments on that.
Thank you, ma'am. In terms of the community liaison group, I don't really have an issue with it. It's not really imposing their will on that. So in terms of being happy with it, I'm happy for that to be as said. So that's not a problem.
So, Mr. Aid, I'm sorry that you haven't been able to have it in front of you, but do you think the principle of a community liaison group would be acceptable to you?
In principle, of course, it sounds like it'd be beneficial, but how it would work in reality, I don't know. But it sounds good.
Okay, Ms. Clubb, have you got any comments?
Yes, I mean, this is really a matter probably for the Community Council to consider, but there are already a lot of liaison groups with the different wind farms. Our Community Council has over 40 wind farms that they have to deal with in planning. It's absolutely horrific. This is a really small community. The burden on them is just horrendous. I really don't know how they do it. It's incredible. It's just so much to ask from people. And you know, so when you start adding in all the community liaison groups as well, which they all have to be part of, I mean, I don't know how they've got time to breathe personally. I mean, it's shocking. You know, so the cumulative effect on this community and those that are actually able. I mean, they're angels, you know. It's just I can't say any more than that, really.
Okay, so you would be agreed in principle, but it was about perhaps about the burden, about how much burden it would place on certain people.
Yes, it's, you know, it's all very well to say, oh, we'll have a community liaison, but they all have community liaison groups, and these people are just totally and utterly overwhelmed. It's awful.
Okay, I understand the point. Mr. Buchan or Mr. Trinick, do you want to say anything else on that?
I don't think there's anything to respond to. Thank you.
Okay. And the second additional question, the second additional proposed condition was on the Transport Monitoring Officer, which we've mentioned a couple of times earlier in the agenda today. Are there any other comments that the council would like to make on that proposed condition?
Thank you, ma'am. No, looking at its in its wholeness, I'm quite happy the way it's worded and the way it's set out, and it's very similar to the planning monitor officer, so but specific to transport. So I'm happy for that to be as is written there. Thank you.
Okay, thank you. I'm wondering whether Mr. Aid or Miss Clubb will want to say anything about. I mean, I could read the condition out in full if you wish, or I can summarise it, which is to propose that there should be a transport monitoring officer that will be appointed by the company, and it would be an independent and suitably qualified consultant acting with the approval of the planning authority. And that would be about monitoring compliance with the TMP, requiring the transport monitoring officer to submit a monthly report to the planning authority summarising works undertaken in accordance with the TMP, and requiring the transport monitoring officer to report to the planning authority any instances of non-compliance with terms of the traffic management plan. That is basically a summary of that condition. So do you have any comments on that, Mr. Aid or Miss Clubb? Mr. Aid?
I would, yeah, it sounds like an okay idea. I would suggest, I don't know if they've thought of this before, but combining that role with a number of traffic monitoring cameras, temporary ones, all along said route of deliveries. And with technology as it is, I'm sure that can be done. And then the monitoring officer, his job is to keep an eye on it, a bit like a security or surveillance man. And this would flash up any problems. We'd also flash up problems like we had huge issues with littering from the last wind farm on the B729. Of course, traffic monitoring cameras would catch them doing this, and all sorts of problems, and catch people flouting regulations, and penalties could be issued and things like that. But I don't know what the developer thinks of that, putting cameras in, but
okay, we could come back to the applicant at the end. Miss Clubb, do you have anything to add?
Yes, I mean, I welcome anything that's going to help this community and to help us to go through our lives and to be able to live in this community and to work in this community, because at the moment it feels bleak. So anything that is thrown in our direction, I welcome with open arms. I really do. But the trust has gone, and that trust needs to be rebuilt. So we're looking for a result of policy that makes things a bit better for us. And even if it's a small thing that works, that would be great, absolutely great. You know, because we all want to live together peacefully. We want this trusted cooperation. If a wind farm comes into the area, we want to we have to live alongside that wind farm, and we want to build a community that's not all fighting with each other and all squabbling about it, you know. So yes, I welcome everything, every initiative, and hopefully by the time the 16 years is up and all these wind farms are built, we'll have cracked it. We'll say, this is how we did it. We'll all be in with our walking sticks. Well, I will at that time. Ben won't. He'll still be a young man, but I'll be in my late 70s, no doubt. And we'll say, well, we did it. We did it. We worked it out. This was a difficult era, but we did it. You know, that's what I vote for.
Thank you.
Thank you.
That's okay. So I'll maybe ask Mr. Trinick if he wants to respond at all to Mr. Aid's suggestion about traffic monitoring cameras.
Yeah, I appreciate the suggestion. That's why we've suggested GPS in the vehicles, so that an eye can be kept on what those vehicles are doing, and that GPS information can be monitored by the transport monitoring officer, and reports can be made about non-compliance with the traffic management plan. As to cameras along the road, I'd be surprised if those would be welcomed by the community, frankly, because those cameras be filming everybody going along the road. I think would be a bit intrusive. I'm not sure it's a very good idea.
Okay. Ms. Clubb, final point on this?
Yes, I would have to think about that. I get Mr. Trinick's point about cameras being intrusive, but we're kind of used to cameras everywhere. And the fact is that at one point I was asked if I would take pictures of all the perpetrators, because there was a lot of perpetrators, I could tell you. It was but I said, no, I'm not doing that. I'm not going to be a spy. You know, that's not my job to go around with the camera and sneak about taking pictures of people breaking the law. It's just fundamentally wrong to ask a citizen to do that. So if cameras are necessary and pictures need to be taken of people that are doing things that they should not be doing, then I'm all in favour of that, you know. But that's for the community to decide. That's not for me. But I certainly don't appreciate being asked to spy on all the people, because that's just fundamentally wrong. I'm not. It's not in my nature to do that.
Okay. Thank you. Right, I think that takes us to the end of section 3. Section 4, we have discussed a little bit of.
Just before you get to the end of section 3, the question has been discussed, the issue rather, of the type of trailer has been discussed, but you don't have a condition in front of you relating to it.
No.
Now, it's up to you entirely. I have a condition in front of me. I can read to the inquiry for discussion now, or it can be put in writing later. I leave it entirely up to you.
I'm just going back to the discussion that we had on that. But it wasn't. I thought, now I'd have to look at my notes. I thought Mr. Buchan was suggesting that we wouldn't need a condition on that, but are you suggesting that we have a draft in case?
Well, I think one needs to be discussed.
Okay.
I won't read out the wording if you don't want me to, but the idea is to have a pre-commencement condition.
Oh, sorry. I think the issue was Mr. Buchan was saying that it would be difficult to draft it because of the different technologies that are out there.
Well, that's why I've drafted the condition I have, to try and get around that.
Okay, great.
And that's why I've drafted it as a scheme condition, not trying to be too specific, looking ahead into the future and not knowing what technology may emerge in order to move blades. But basically, it's no development shall commence till a scheme for the delivery of AILs, abnormal divisible loads, to the site has been submitted to and approved in writing by the planning authority. The scheme, which should be implemented as approved,
You don't think it's necessary then?
have
You don't think
regard.
this is necessary?
So Mr. Douglas doesn't like the condition, but
sorry,
he's saying it's not necessary.
I thought my microphone was off, and I was just checking with Mr. Morrison. It wasn't my dislike of the condition.
I can't continue. So have regard to the desirability of avoiding undue conflict with other traffic movements. Now, that condition doesn't preclude any particular blade delivery technology.
Okay.
But it does acknowledge the need to keep traffic moving. And it's a basic condition, but I think it does at least provide for a trigger mechanism within the consent to consider what might be desirable by way of delivering AILs. I leave it there for consideration. If people think it's not necessary, well, that's fine.
Do people want to discuss that just now, or do we want it to be submitted thereafter? Mr. Armstrong?
I think it would be helpful to see it in written form, but I was just discussing there with Mr. Morrison, which I thought was off microphone, just checking that his evidence was, as was set out earlier, that it wasn't necessary, and he confirmed that. But it would be helpful to see it obviously in written form if it's going to go any further.
Well, I think
at least you weren't rude, Mr. Armstrong. You could have been very rude there.
Right. Well, I suggest it'd be better maybe if Mr. Trinick is happy to just email that in afterwards, and so that we can all have a look at it, and it can be part of closing submissions if necessary, if people want to say something on it. Is that okay, Mr. Trinick? I didn't hear an answer, but I think you nodded. So.
Yes, that's fine. Thank you.
Right. Okay. That's great. Thank you. So in terms of section 4, I am presuming that the answer to A is that there aren't any changes at this stage, but I would be grateful if the applicant could confirm whether there's any changes to the abnormal load route as set out in Appendix 15.1.
No changes.
No. And is there anything more that we can say at this stage, and under question B here, about mitigation measures in relation to any visual effects of the transport elements? We've also talked about the tilting trailer and how that might reduce possible effects relating to the off-site roadworks, but assuming that we're not using a tilting trailer, what can be said at this stage about mitigation measures?
Well, ma'am, the mitigation measures are set out in CD1, whatever it is, 18, section 3.3, which does provide not only a summary of baseline conditions, but adopts a target point approach to the assessment with an accompanying figure 311 in the AEI2, taking us from point 07 right through to the site and into point 15. Each point, the landscape and visual effects are assessed on the basis of a standard trailer, and in no case are significant effects predicted. Then there's a summary at the end. I'm not sure what more I can add. An assessment, an EIA assessment of the effect of the off-site works has been provided.
Okay, I think it's perhaps following up some of the comments from Dr. Swales yesterday and some of the comments that she's made in her own evidence. So I don't know whether Mr. Armstrong would like to say something more on this.
It was just in relation to Dr. Swales' evidence yesterday. She did refer to her appendix to her report CD12-1, and I think really the relevant passage is on paper copy page 94, paragraph A 3.5.3, which was the request for further information. And I don't think there's really anything further to add on that point in relation to.
But so I think my understanding was that that Dr. Swales was looking for more detailed, perhaps photomontages or tree survey information, that sort of thing, to help inform the assessment. But in the absence of those, do we think that these matters could be addressed through a condition and signed off at a later date, Mr. Armstrong?
I think that would be over to Mr. Morrison to.
Thank you, ma'am. Yeah, I think we could put a condition into that effect that we want to have some idea of the mitigation measures regarding the visual effects and for the transport elements. That's something that we could definitely condition. Yeah.
Mr. Trinick, do you think that's something that you could work up a draft of alongside the condition that you're going to give us on the trailer?
If necessary, ma'am. I think I'll leave it to Mr. Gillis, who's going to deal with conditions more generally, but I rather suspect that the construction management condition may actually cover that point anyway, where it's only a question of adding a separate paragraph to that condition.
Okay.
It's quite simple to do.
What condition is that, just as a matter of interest, the construction management
number
one?
offhand, but Mr. Gillis is looking as we speak. It's the construction environment management plan we're looking for. Thanks. You bear with me a moment, we'll give you the number.
Is it
20.
20, yeah.
But that would seem to be the appropriate place to insert something.
Okay. That's very helpful. Did Mr. Aid or Miss Clubb want to say anything more about the abnormal load route and the measures required there?
Nothing at the moment. No, thanks.
Okay, thanks. Miss Clubb? Yes?
This is really the B729 where I don't know if I've picked this up right. You're talking about, is this 4B where you're talking about the environmental impacts on the B729?
Yes, it's the works that would be required from Carsfairn down to the site entrance to accommodate the trailer.
Yes, so what I'm going to suggest is something that's slightly, it's to do with that topic, but it's not really. It's kind of, I'll just go and come out and say it. The conditions. What I've become aware of actually very recently is that once a development has been given permission, there's all these conditions that are attached. And I think most people aren't aware of that. And we assume that once it's been past that set, they just get on with it. And there's not. There's obviously years in which the council negotiate these, work through these conditions. And I wondered if you know, and obviously the whole landscape, all this landscape stuff is getting put into this condition about the road, which is where what this 4B ties into, is that could be a condition put into the conditions that the community continue to be consulted on how the conditions are being mitigated or taken away, or whatever the word is, because from my perspective, I had no idea that there was all this going on in the background, and this is where the traffic management plan came in, because with Windy Rig, it seemed to be that the traffic management plan seemed to somehow come out through the conditions.
Okay.
And that was something we were completely unaware of before, after it had been passed. So it kind of comes out of the blue. And in fact, the traffic management plan, I only discovered about it because I said, hey, wait a minute, Windy Rig's about to start going up and down this road and blocking us in. Shouldn't we have a risk assessment? And I went to the community council and asked, you know, we should have a risk assessment because there's going to be problems, because I've been here before, I know all about this. And,
okay.
and eventually out comes that, oh, there's a traffic management plan. Oh, I didn't know about that. We should have known about this before. This is something we should have discussed before the planning went through. But hey ho, it's all, we had, eventually it came in. Now, the trouble was that this traffic management plan that came in from Windy Rig it was so big that it couldn't be shared with the general public, the general community, because you couldn't attach it to an ordinary email. So it was like for people that had great computer skills could see the traffic management plan, everybody didn't. So nobody in the community that mattered had actually ever seen the traffic management plan, probably till about 6 months after this whole fiasco started. So they had no idea that in actual fact they had in the traffic management plan a right of way. So it came as a great surprise to everybody. that this was there. So,
okay,
it's another. So what I'm saying, what I'm trying to say in terms of 4B is that, is there any way that we can have conditioned that the community are kept up to date on how the conditions are being dealt with, so that we
I understand the point, yeah.
when it starts, and particularly, and there'll be a lot of people in the community that will be very, very concerned about the environmental aspect of the B729, particularly the people that live alongside that section.
Yeah.
I don't live on that section, I just travel it, but there's a lot of very environmentally aware people, including the community woodland group, that will
okay,
be
I think I understand the point, and I think both the applicant and the council should have an opportunity to respond on that. Who would like to go first? Mr. Morrison. Yeah.
Yes, just to follow on first from Mrs. Clubb's comments there. The decision notice is online. It's on the plan portal, and people can see that. The online traffic management plan is also online, so people can access that. The case officer, if you click on the contact details from the online application form, you can find all this information online as well. So it is viewable to the public, and it is accessible as well. Thank you.
Can I also ask Mr. Morrison, is there what specific mechanisms might there already be built in terms of communicating how the conditions are dealt with? Would that come through perhaps the community liaison group or other communications?
Yeah, I think yes. Basically, it's the plan officers who will discharge the conditions in consultation with ourselves in terms of if the TMP is appropriate. So in order to kind of maybe communicate that, I think it would have to discuss it with the planning authority to see how they would like to you do see online where there is like a discharge condition or a document relates to the condition 22, for instance, is TMP. So there will be a document online that says discharge relating to condition 22, and they can look at that and view that. That's certainly available for all the public to see. So there is evidence online on the planning forum which shows how the conditions are discharged.
Okay, thank you. Mr. Trinick, could you say anything about how that might be addressed, Ms. Clubb's concerns?
Yes, to be fair to Mrs. Clubb, that can be a problem in practice because it may be on the portal. There's no, whereas with the planning application, there's a duty on the planning officers to liaise with the public and to consult. When it comes to the discharge of conditions, it's a bit different. And that's why I think the community liaison group condition could be quite useful here in order to bring matters proactively to the attention of the community rather than relying on them to look at the planning portal.
Okay, that's helpful. Great. Okay, so I think I don't think we need any further discussion under 4. And I don't propose, given the time, to discuss any other matters. I think we've covered everything that I wanted to cover. Are there any other matters that anyone else wanted to raise at this point? And obviously I'm conscious that I've said to Ms. Clubb and to Mr. Aid if they wanted to make a short statement at this point, if people have the time just to allow that, then that's fine if you want to do that, Ms. Clubb, but you may feel that you've said everything you want to say. Ms. Clubb? Sorry, Mr. Armstrong first.
It was just that there's obviously the traffic and transport conditions, but I suppose they could be dealt with tomorrow with the other conditions. And Mr. Morrison's enjoyed himself so much today that he's happy to come back tomorrow to deal with these conditions tomorrow. If that.
Well, I mean, to be honest, we don't mind either way. We can stay on if you want to discuss those transport conditions today. We felt perhaps there was more pressure at your end, but it's up to you. What do you think?
I think, well, I'm just saying that Mr. Morrison's happy to come back tomorrow. So yes, we can deal with these conditions tomorrow.
Right. Okay, that's fine. So Ms. Clubb, would you like to say anything further at this point?
Yes, just something very, very briefly. I'm aware that we've been speaking a lot about Windy Rig today, but I'd like to pass something on in terms of traffic management to Shepherd's Rig that is very relevant to themselves, if they get the permission for the wind farm. So the B729 from Carsfairn to their site entrance is, as we know, very, very twisty and a very dangerous road. In terms of risk assessment, in terms of traffic management plan, Windy Rig did put up speed signs. They did consult with us at one point, and we told them what the speed limit should be, and they ignored that. They put up 40-mile-an-hour signs to say to their workers, it's okay to go at 40 miles an hour in this road. And as a local resident, I would say it is not okay to go at 40 miles on that road. That is in terms of safety, it is a 20 to 35 mile an hour road max. There are short sections where it is possible to go safely at 40 miles an hour, but this is a slow road, and all transport workers, all the workers need to be very aware that all the way from Moniaive to Carsfairn, this is a slow road, and that's the message that I would like to pass on.
Okay, thank you very much for that. Mr. Reid, did you want to add anything else that you've not been able to say?
Nothing specific, no, just that Carsfairn Community Council and the majority of Carsfairn residents don't believe that Shepherd's Reed's an appropriate development for lots of reasons, including the transport issues. That's all for now.
Okay, thank
Thanks.
you, Mr. Reid. Can I just ask if the applicant or the council have anything else to add at this point?
No, thank you, ma'am.
Mr. Armstrong?
Ma'am, I've got nothing to add in relation to this session. I do have a sort of housekeeping matter, 3 points, which
go ahead.
I would raise.
Give us those now. Yeah,
whether you
no,
want
give
me
us
to do
them
that
now.
just now.
Yep.
Yeah, we're obviously coming back tomorrow, and it would be helpful, ma'am, just to get some guidance in relation to three matters, which perhaps either think about overnight or come back in the next few days. Or when you feel able to. The first is in relation to the response to the draft NPF, and I'm told that Mr. McTeer, for a variety of reasons, and I'll come on to two of them, would have difficulty completing a response in under six weeks from Friday. And one of these reasons is that Mr. McTeer has other commitments and would have considerable difficulty in processing this in the time. But it would be a matter also, I understand, that would have to go to the head of planning, because, ma'am, you'll appreciate the council will obviously be responding to the draft MPF, and the council have yet to take a decision on how they will respond to that. But that response will likely involve issues of interpretation of the draft, that would mean that the head of planning would have to consider the submission that the council are going to make to you before it actually went into to you, ma'am. So these are really the two reasons why we'd be looking for a 6 week period to respond. I suppose the second point that follows on from that was it would be helpful to get guidance from you in relation to the date of the actual closing submissions. It would seem that that perhaps the most logical way forward would be for the closing submissions to be after that the response to the draft MPF was in, because obviously the closing submissions would potentially would make comments on the submission in relation to the MPF. But it would be helpful to maybe have a thought about what the timetable for closing submissions. And the third point is a point that Mr. Trinick raised at I seem to recall, at the pre-inquiry meeting, and that was in relation to the summary of evidence submissions. And it would be helpful to get some guidance on that, and whether it's a full summary of all of the evidence, because from each witness, because obviously most of the evidence is in written form, or whether it's a summary of just the key points from the oral submissions that you've heard this week, and to get some guidance on what you're both looking for in relation to that summary. I think Mr. Trinick said he was going to make further submissions about whether we should be doing summaries, but the council is sort of happy to oblige on the summary issue. It would just be helpful to get some guidance on that. And these were the 3 points I just wanted to raise now, and maybe discuss tomorrow.
Yeah, those were certainly things I was planning to discuss tomorrow. I think maybe given that you've made those comments, I wonder if Mr. Trinick wants to say anything just now, and then I can obviously give you our thoughts about what we were thinking just now, to then maybe allow us all to think about it overnight and then hopefully agree tomorrow. So Mr. Trinick, would you want to say
Yes,
anything?
thank you, ma'am. I think if the 6-week period was going to hold up the decision, I might have something to say, but it won't. So I'm perfectly happy with the idea of 6 weeks for the council to deliver its submissions at MPF4, and we can come in a week after that or at the same time. I say at the same time because there's no need for us to have a right to respond to those. We can respond in the closing submissions, so we might as well submit them on the same date. That's fine.
If those are after, yes. Okay.
Closing submissions, I think, should be after that exchange. It makes no sense to have them before. Timetable to be discussed. In terms of summaries of evidence, it's clearly an evolving topic under guidance note 3. I understand that. My proposal, for what it's worth, would be to give an overview of the case in a couple of pages, which would, I hope, fairly reflect the evidence as given at the inquiry. As opposed, I don't see any point in using precognitions for summaries because that gives a very one-sided impression of the case. You want to know our impressions of the case, having heard the evidence, in other words, on a rounded basis, I imagine. So that's my proposal.
Okay, that's great. Well, it was just to say that certainly going back to what we said at the pre-examination meeting in terms of timing on item 2, which is the date of the closing submissions, we had talked there about those being submitted by the council and the other parties 2 weeks after closing, and then the applicant 2 weeks after that. So that was what we originally thought, but obviously I think Ms Haywood and I will go away and think overnight about how it all ties in with this MPF consultation draft and the idea of 6 weeks being the response time for that. And certainly on the summaries of case, that sounds, I mean, what we were looking for. And again, we'll come back to you over once we've had a think about that overnight. Come back to you and hopefully confirm and agree the 3 matters tomorrow. So I think that's all we need to discuss today. And yeah, Mr. Trinick.
So one matter, ma'am. I will not be here tomorrow.
Okay.
Inevitable circumstances meant I've got to return to base.
Okay.
Mr. Gillis will be sitting in this position tomorrow to close the inquiry. After he will deal with conditions and deal with closing the inquiry. I apologise, ma'am, but it's unavoidable.
That's no problem, and thank you very much for your input this week.
Thank you.
And in terms of the council, we've got Mr. Armstrong and Mr. McTeer and Miss Whitelaw. Is that correct? Yeah.
Yeah.
And Mr. Morrison, is he going to appear? Yeah. Great. Well, thank you all very much for your time and your patience and stamina during these sessions. Thank you, Ms. Clubb and Mr. Aid in particular for coming along today and giving us your perspectives. Yes, thank you very much, and we'll close off tonight and we'll see. Oh, Mr. Armstrong. Yes.
Sorry, one point. I wonder if it would be possible just to, so as Mr. McTeer can check whether his sound is working again, if we could stay on and just do a check once.
Yes,
if
certainly
that's
we
possible.
can do that.
I think that would involve, is Mr. McTeer already invited in as well? Yes, that would be helpful. Thanks very much.
Okay.
He's there, yes. Thank you.
Sorry, ma'am, it's in 9:30 tomorrow morning?
Yes, 9:30 start again, access from 9:15 hopefully. Ms. Clubb, you just have a point there, do you?
Just to thank yourself, Miss Levin, and Miss Haywood for an interesting experience.
Well, I hope it's not been too painful.
It's not been you've made sure it's not been too painful for me. No, thank you very much for that. And I'm glad you enjoyed the story about Lazy Bob.
Yes, I won't forget that. Okay, that's good.
Thank you very much. Thank you.
Okay, thank you. Bye.
Well,
So if the rest of you want to switch off, feel free.